We will now call the Beaufort County Board of Education Board Work Session to order. This is a two-day work session, August 14th and 15th, 2020. Today is day one of the work session. The session is being conducted via remote video conferencing. It is not on the county channel, so where the agenda is posted, they have the links on how to join for the public to join by phone or to be able to view the meeting. And so that is why in the participant list today, we have a lot of guests, and I believe those are people who are observing. So,
I need a moment.
are you good to go or not yet, Robin?
I'm good to go, ma'am.
Okay. So our first order of business is approval of the agenda. Do we have a motion to approve?
So moved.
And a second?
Second.
Ms. Fidrich?
Was Ms. Robine the first one?
Yes.
Yes.
Any discussion? All right, voting is now open.
Aye.
Not yet, not yet.
Okay.
Sorry. Voting is now open.
Okay.
Aye.
Who is I?
That was me.
Dowling.
John, oh, I'm sorry. Thank you.
So I'm I also, but it doesn't come up on board docs. I logged in there when it was still draft. Is that why?
Yes, that's why. You have to
Okay.
refresh and go in.
Okay, thank you. So I for Guads.
Wisniewski, aye.
For Campbell, Mel.
Is Mr. Smith on?
I don't see his name. in the
Ms.
participant
Borshak
list.
is not on.
I
Okay.
don't see her name either.
She is not going to participate until after lunch.
Okay.
All right, so I'm closing voting.
So the motion carries to approve the agenda 800 and 3 members absent. Orishak, Smith, and Earl Campbell.
Mr. Campbell's muted. I'll go back and change his vote.
Yeah, he was here.
Okay. Mr. Campbell, your vote is a yes, correct? Okay.
All right, so
I'll
motion
change it.
carries. Can you refresh it, please? I believe it's
Yes.
9. It will be 9002, 2 members absent, Orishak and Smith. Next on the agenda is the Pledge of Allegiance. Please stand. I pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The media has been properly notified. We'll have a moment of silence. All righty. Next up are our public comments. So I'll turn this over to you, Robin.
Can you hear me?
Yes.
Yes, ma'am.
Okay, go ahead. Say your name, Sean.
Sean.
Can you hear him?
Yes.
Yes, can you state his last
Okay,
name,
go ahead,
please?
Sean.
Robin, can you have him state his
Sean,
last
what is your
name?
last name?
Apgar.
Thank you.
His last name is Afgard. Go ahead, Sean.
Well, basically, my concern is with the school closing. With the numbers and stuff I see from the CDC, and y'all's numbers must be totally different because, I mean, last I checked, I think we had 65 deaths in in Beaufort County in the past 8 months, and of those 65 deaths, only 55 of them were above 65, and then also the other 10 were 35 to 65. So obviously, kids are not at risk at all to a point for the virus. I mean, if you look at those numbers, and I mean, kids that, use this for an outlet for so many different reasons. I mean, 5014 plans, IEPs, for, abuse at home, so many different categories of where this is an outlet for children. I think we're doing tremendous damage to them in the long run for academic reasons, for, the list goes on. So, I mean, just for us to shut it down and give no kids no option and just go virtual learning when I thought the county was supposed to, offer both ideas, I mean, I think it's a little absurd.
Is that it, Ms. Sean?
I mean, yeah, for the most part.
All right. Thank you. That's it.
Mhm.
Now, on the next one.
Hello?
Hello, Amy?
Yes.
Will you state your first and last name, please?
Yes, Amy Turner.
Can you all hear her?
Yes.
Go ahead,
Yes.
Amy.
Okay. Hello, my name is Amy, and I am a teacher in Beaufort County Schools, as well as a parent of an elementary age student in Beaufort County. We signed our child up for the 2021 school year. We chose face-to-face because my husband and I both felt that was the best option for our family. Unfortunately, our county incident rate and percent positive cases continue to be high, and in order to ensure the safety of everyone in our schools, Dr. Rodriguez decided to open virtually. I fully understand the strain that this puts on many families in the county. Contrary to what some people may believe, teachers and staff are not able to bring their children to schools, and my husband works full-time, so we are having to figure out childcare just like everybody else. With that being said, my husband and I both fully support Dr. Rodriguez's decision to begin school virtually. Fortunately, we were able to push our start date back, and it has allowed us to see some school districts in neighboring states that have had to now close schools and go virtually because they need to stop outbreaks. So we are able to see that firsthand. Yes, they say children under 10, which is 4th grade and under, aren't susceptible to the virus, but everyone who cares for our children is. What happens when these people start getting sick? Who is going to teach our children? We only have so many substitutes. There are many factors that play into this decision. Now, I'm not from Beaufort, but my husband and his family are. We are impressed with all Dr. Rodriguez has done for our county schools in the short time he has been here and how he has handled this difficult situation. Dr. Rodriguez, my family stands with you. I cannot imagine the stress that you're under in making this decision. But remember, don't let the naysayers get you down because you have a lot of people standing in your corner.
Are you finished, ma'am?
I'm done.
All
Yes.
right, thank you. Hello, is this Kate?
Yes,
Will you state your first and last name so we can make sure we can hear you?
Kate Tiafolo.
Can you hear her?
Yes, yeah.
Can you all hear her?
Not
Not
currently.
now. If she's speaking now, we can't hear her.
Kate, try again.
Kate Chiafolo.
Yes.
Mhm.
Yes, go ahead.
Yes, I was just calling to discuss virtual schooling for the kids who are more vulnerable, specifically ESOL.
Wait a minute. I'm sorry, Kate. You can't hear her now?
I could hear her.
Oh,
Yeah.
Hold on. All right, my internet is dropping. Let me try again. I'm sorry, Kate. Can you start again? Can you all hear me?
Yes.
Yes.
Can you all hear me?
Yes.
Yes.
Go ahead, Kate.
Yes, thank you.
Now we don't hear her.
Can't hear her.
Robin, can she dial into the meeting directly?
I think it was my internet that just dropped her. Can you all hear me?
Yeah.
Yes.
Yes.
All right. So Kate, try this one more time. I'm sorry.
Third time's
Yes,
the
I was
charm.
calling to request consideration for special vulnerable groups, ESOL, special ed. We have an 8-year-old with special ed who we did virtual schooling with in this spring, and it was found to be very difficult, much more difficult than our typical learning children. I was wondering if there's any way typical or special ed kids can attend school at least a couple mornings a week, a couple times a week, to be able to go in. And I think that would be much more effective for them than trying to completely virtual school. Just wondering if there is any consideration being made for those groups.
They can't answer you at the moment, but they heard your questions. And so did you all hear her question?
Yes.
Yes.
So they did hear you.
Thank you very much.
Thank you. That's it.
Okay. Thank you. So we're a little ahead on our agenda. So we can have Wendy, I believe it's Wendy Cartledge, begin her 1 hour allotted time slot for the administrative regulations now, and then take a 15-minute break after she's finished. Or if she's not ready to start, we can break until 9. Ms. Cartledge?
Muted.
Okay. Can everybody hear me? Can you all hear me?
Yes.
Yes.
Okay, good. Thank you. All right. Good morning, members of the board
Good
and
morning.
Beaufort County School District staff. Thank you for the opportunity for me to speak to you with respect to the new Title IX regulations issued by the U.S. Department of Education that go into effect today. And in my 1 hour time that I have allotted, I'm going to give you an overview of the new Title IX regulations. First of all, Title IX provides, the law states that no person in the United States on the basis of sex shall be excluded from participation in, be denied the benefit of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance. For the first time, the U.S. Department of Education's Title IX regulations recognize that sexual harassment, including sexual assault, is unlawful sex discrimination. The department had previously addressed sexual harassment only through guidance documents, which were not legally binding. Now these regulations impose important legal obligations on school districts as well as college and universities, and require a prompt response to reports of sexual harassment. This final rule also the clarity and transparency of the requirements for how schools must respond to sexual harassment under Title IX, so that every complainant receives appropriate support. Respondents are treated as responsible only after receiving due process and fundamental fairness, and school officials serve impartially without bias for or against any of the parties. In the two administrative regulations that you have in your board docs, there is an administrative regulation for staff and adults, and there's also an administrative regulation for students. These new federal regulations require that the district provide notice of who the Title IX coordinators are on the website. And our district is in compliance, and this notice of non-discrimination and all the information concerning the Title IX coordinators are posted on our website. This notice is also being posted on all of the school websites, and I want to thank the technology and communications departments for their prompt response, making sure that we were in compliance with these requirements. The Title IX coordinator for the adult personnel is Ms. Alice Walton, and the Title IX coordinator for students is Ms. Kiki Swinton. And Ms. Walton and Ms. Swinton, along with other staff members, have received their mandated Title IX coordinator training, which is required as part of these new regulations. Now, it's important to note that sexual harassment, as defined in the Code of Federal Regulations, has specific requirements and definitions, and those are listed on 2A. And as you see, number 1 is an employee is conditioning an aid, benefit, or service on an individual's participation, unwelcome sexual conduct, and you may have heard the term quid pro quo, this for that. The second one, unwelcome conduct is determined by a reasonable person to be so severe, pervasive, and objectively offensive, it denies a person equal access to the district's educational programs or activities. And 3 is very specific with respect to definitions of sexual assault, dating violence, and domestic violence, and stalking, and those are all federally required. Sexual harassment does not always have to involve physical contact with the victim, and sexual harassment can occur with respect to social media, email, in-person, postal mail, handwritten, or other communications. The educational program or activity that is defined in the code as any activity or program, including any locations, events, or circumstances over which the district exercises, quote, substantial control. And that would mean our sports activities or activities that we participate occur off campus. These new rules are very specific with respect to the filing of a formal complaint. This formal complaint, it can be signed by a complainant, it can be signed by a Title IX coordinator, and with respect to a student, the parent or legal guardian can file a formal complaint. Of course, complainant is the person who is alleged to be a victim of any sexual harassment. The actual knowledge means that we have been put on notice of sexual harassment, and any employee could report this information to the Title IX coordinator. The Title IX coordinator and Ms. Walton and Ms. Swinton are very aware of what the responsibilities are and the requirements, and Ms. Walton has very diligently been assembling teams to work on these sexual harassment complaints and the event that they occur. They have to be trained, as well as not only the Title IX coordinators, but the law requires now that investigators, decision makers, any person facilitating an informed resolution, appellate decision makers, they must receive training on the definition of sexual harassment, the scope of the district's educational activity, how to conduct an investigation, what the process is, appeals, informal resolution. Very important, how to serve impartially. They must avoid any prejudgment of the facts at issue, must avoid any conflicts of interest or bias. In addition, they have to be trained on relevance of questions and evidence. Investigators must receive training on the issues of relevance in order to create an investigative report that summarizes the evidence. And all of this material is going to be available for, on the BCSD website. Something that is new in the law, which is going to be very helpful for.
Can I interrupt a minute?
Yes, ma'am.
We got a note from Mr. Dowling that Wendy is fading in and out and that there's an echo.
Oh, no, okay. I'm at the office because the internet does not work well at the house.
I think when you turn your face to read something away from the computer, that's when you fade.
Okay.
So if you're looking
directly, Mr. Dowling, okay. Let me try to face more forward because I want to make sure that you can hear me. So I apologize for that. Thanks, Mr. Dowling. Thank you. Okay. Supportive measures. Supportive measures is a new requirement in the law, which will provide benefit to the complainant and the victim. The Title IX coordinator must promptly contact the complainant and as well as the respondent to discuss with the complainant their wishes and their desires to receive supportive measures. And some examples of this would include counseling, course modifications, scheduling changes, modifying work schedules or locations, mutual restrictions on contact between the parties, providing leave of absences, increased monitoring or supervision. And the district's Title IX coordinators, they must offer this whether or not a formal complaint is filed by the complainant. And in the event that a formal complaint is filed, and we have included, Ms. Cushenberry's included the formal complaint form there so you can see what it consists of for students of our staff. Once that formal complaint is filed, then the district must treat all the parties equitably and fairly. There has to be an objective evaluation of all of the evidence, and that includes, inculpatory and exculpatory. They have to look at the entire situation. Anybody that's serving in a role cannot have a conflict of interest. There is a presumption that the respondent is not responsible for the alleged conduct until a termination has been made at the conclusion of this grievance process. There are also procedures. The notice is given right away. As soon as a formal receipt of a formal complaint has been received, then the district is required to provide a written notice to all of the parties and to give time for the preparation of a response before an initial interview. And that notice requirements, they're listed there. Number 9, there are 5 requirements that must be put in writing so that everybody is on notice and is aware of what these allegations are. The only time when a complaint would be dismissed under Section 10, it must be dismissed if the allegations do not fall within that definition of sexual harassment that I told you about in Section 2A, and also if it did not occur in our educational program activity, and the law says it did not occur against a person in the United States, and that's in the federal regulations. A complaint may be dismissed if the complainant notifies a coordinator in writing that he or she wants to withdraw it, if respondent's enrollment or employment ends, or specific circumstances prevent the district from gathering sufficient evidence. And if there is a dismissal, then there must be prompt written notice provided. But now with this new investigation process that's mandated by the Code of Federal Regulations, there are very specific requirements of what the district and the investigator must do. And those are listed in detail in Roman numeral 11. And those are steps A through G of, what must be done. So this is a very specific formal process that mandates fairness for both the complainant and the respondent. Then after that investigation is completed, after that time, there's a written report that summarizes the evidence, and the report is given to both the complainant and the respondent and their advisors. And an advisor can be an attorney or it can be another individual. It is up to the particular complainant respondent of who they want their advisor to be. That is their choice. After the investigator has sent this report, there is a decision maker that is separate from the Title IX coordinator, that is separate from the investigator. The decision maker provides each party 10 days to respond to the investigative report, and they also have the opportunity to submit questions that the party wants to ask of another party or witness, and those answers have to be provided. And the decision maker issues a written determination, and then again, the very specific requirements of what must be included in this decision maker's report, and those are items 1 through 7. So this is very detailed and very these are mandated. You have to have findings of fact, rationale for the decision for each allegation, and then you also the decision maker must also inform the complainant and the respondent about the proper procedure for them to respond and to appeal if they wish to. And Roman numeral 13 discusses the specific requirements of the appeal process. And this is all part of due process. If there is a procedural irregularity, if new evidence becomes available that was not available at the time, if it is determined there's a conflict of interest on the part of the Title IX coordinator, the investigator, or decision maker, and in all appeals, the BCSD will provide written notice to both parties of the appeal and provide both of the parties equal opportunities to submit their written statement. The parties will have 5 days to provide their response. The decision maker for the appeal cannot be the same person as the decision maker that reached the determination regarding the responsibility dismissal. The decision maker cannot be the investigator, or the Title IX coordinator cannot have a conflict of interest and must receive training. And with respect to the school district, we talked about this in the operations committee, and Ms. Walton concurs with this, that in the event there was an appeal, then we would have the appellate review person be, an individual that is not affiliated with the district in any sense at all. And the South Carolina Bar has a list of certified mediators in the area. These are attorneys that are trained, in dispute resolution, and that would be a possibility of who the district could obtain, because we want to make sure that there's free from bias and there's no conflict of interest. And Mr. Dowling brought up a very important point too, because it's not only an individual, it has to be an individual that has no financial interest, indirect or indirect, trying to get any economic benefit for himself or a member of his family. So we would find somebody that is totally disinterested. Something else I wanted to point out to you all is there's an informal resolution process. However, if there is an allegation of sexual harassment by a teacher against a student, the informal resolution process cannot be used. This informal resolution can be used during the formal complaint process. It can be offered to facilitate a resolution, but that would only be if the parties are given their notice of rights and that they agree and consent to it. And like I stated, it cannot ever be in the context of a complaint that an employee harassed a student. That is prohibited. In the event that there is an immediate threat of harm, the district has the authority for emergency removal, administrative leave of an employee during the investigation and grievance process. Another requirement for our district and for all districts is this: the record keeping requirements mandate that this district will maintain records for 7 years. And these records are for each investigation determination, 2, for any disciplinary sanctions that are imposed on the respondent, 3, for any remedies that have been provided to the complainant, any appeal on the result, any informal resolution and result, any materials used to train Title IX coordinators, investigators, decision makers, and any person who facilitates an informal resolution process. And I wanted to point out to all of you that one of the Office of Civil Rights initiatives for the 2020-2021 year is to conduct compliance reviews on districts throughout our country. So it is very likely that there will be a compliance review on our district as well as many other districts in South Carolina. The Code of Federal Regulations also prohibits retaliation, and this district nor any person may intimidate, threaten, coerce, or discriminate against any individual for the purpose of interfering with their rights under Title IX, or because that individual made a report, a complaint, testified, participated in, or refused to participate in any investigation or proceeding under Title IX. We are also required to keep confidential the identity of any individual who makes a report or a complaint of sexual discrimination or sexual harassment. Any complainant, any individual reported as a perpetrator, any respondent or witness, except as permitted under FERPA or as required to carry out the purposes of these Title IX regulations and the procedures. And also charging someone with making a false statement in bad faith does not amount to retaliation, provided that a determination regarding responsibility alone is not sufficient to conclude that any party made a materially false statement in bad faith. Now, there are specific timelines for this process, and it takes a long time. The grievance process will be completed with 120 days. The only way there can be a delay or an extension would be if there was good cause, and that would be something if a party was not available, if there was a party's advisor or witness had a delay for some type of medical, or say we had a hurricane or something like that. And we also have to provide, of course, for language assistance and accommodation of all people with disabilities. I have included the legal references in here for your review. And on the sexual harassment and retaliation complaint form, we have one for the students and one for the staff, which is basically the same thing. But as you can see on here, we're asking, and this is required by the regs, very specific information the date the conduct took place, the locations, the persons who engaged in the conduct, any witnesses, evidence, emails, photos, text messages. There may be requirement for video surveillance at a school, describing the incidents, and it says right here, it has to be filed on an honest belief that this particular respondent has engaged in conduct involving harassment, retaliation, requesting a resolution or outcome, and requesting that the district investigate the allegations of sexual harassment that are outlined in the complaint. And I wanted to let you know that Ms. Walton she's already been working on this very diligently, and she can explain this better than me, but she has a system worked out to be able to track all of these complaints that are received by the district and to monitor them and to keep all those records, because if we receive a compliance review by the Office of Civil Rights, we want to have everything in order for the district, and we want to make sure that we comply with these laws. And they're, like I stated at the beginning, this is a very detailed process that must be followed, and we want to offer supportive measures. We're going to train all of our employees about this too, as well. And, it is my hope that we can, as much as possible, that we can prevent, by educating our staff and our students, that we can prevent sexual harassment in our school district, because when this thing happens, it prevents our students. They're not able to receive the education that they need, and we want to protect them, and we want to protect our staff, and we want a workplace that is safe and where everybody is treated with dignity and respect. So I'm very pleased that these regulations are in effect now, and we are going to do our best here at the district to comply with all of these mandates and regulations. 9:07. Can I answer any questions that you all might have here? I had to be very, I'm sorry, that it's so much legalese, but I had to, we had to reflect the mandates and the federal regulations, so that had to be followed specifically.
Thank you, Wendy. Before we go to Q&A, we have to do one housekeeping item, and that is the person that is using the iPhone to connect to this meeting, could they please identify themselves, because it is required by law that we know which members are present and which are absent for this business meeting. The person that's using the iPhone.
That is me, as William Smith.
Thank you, William. Okay, we'll mark you as such. Thank you.
Oh, good. Good morning, Mr. Smith.
So now, could we please have any questions, and Wendy will provide answers.
And also, I wanted to ask Ms. Walton if she could please let the board know about the program she set up for monitoring these complaints, because I think it would be helpful for the board to know what has been done.
Good morning, everyone. Can you hear me?
Yes, very well.
Okay, great. I am, as you can see, this is very intricate. There are a lot of details and there are a lot of specifics that we're needing to add. We're up to this point, we have a sexual harassment policy in place, but the new guidelines really tightens it up to a point that it's almost legal. So one of the things that I ask your understanding on is we have complied to the law up to this point. We're in compliance as to the August 15th deadline, 14th deadline. So my team and I that were trained this week are going to meet next week and put together our compliance team that will serve the entire district. Because we are a larger district, it is no need for us to begin this small, have one compliance officer or two compliance officer, and we're dealing with a district of 22,000 students. So my goal is to put together our org chart of how this is going to look, how the complaints are filed, what's the first step, what's the second step, list all of the investigators, list the mediators, the decision makers, and our appellate person to serve in this role. One of the things that our community partner, and that's the organization that we're working with to make sure that we are in compliance, stay in compliance, and do whatever we need to make sure we are on the law, is going to work with us in terms of making sure those people that we put in place serve us well. And their advice is that human resources really should not be the appellant, because we have so much connections with employees in the district. So we're working through that process. And in the interim, we are putting together a system to track all complaints. And that's across the board, from local grievances to sexual harassment complaints. And that system will store, organize, manage, and it will allow us to pull any grievance, any complaint. If we're ever investigated or if we're ever audited, all of our information will be in one place. So that's what we are working out right now. And I asked the board to give us a little bit of time to get this together so that we can bring to you very specifics of how this is going to work.
Thank you. Mr. Dowling has a question.
Mr. Dowling needs to be unmuted. Here we go.
Thank you.
Thank you, Kathy. My question is for Alice Walton. What is the scope of this problem? How many complaints does the district average a year?
We average between, are you talking about sexual complaints specifically, or just complaints, period?
Anything that would now fall under Title IX.
I would say 2, maybe 3, not very many, some years none.
Oh, okay. Thank you.
Another housekeeping issue, could the board members please remember to take down their electronic hands after they've been recognized? Thank you. There being no further questions, would you like to go on to the foreign exchange students?
Yes, ma'am. Thank you.
Okay.
Madam Chair,
Yes.
I apologize. I was holding my question until we addressed SS 14.1. So are we jumping down to IS 58?
Well, actually, I wasn't sure whether Wendy was going to go through she mentioned both of the 3.1 and 3.2. So, and she mentioned those complaint forms. Ms. Cartlidge can address that, sorry.
So, Ms. Fidrich, so we had, I appreciate everyone's time on academic committee. We had spoken and reviewed this administrative regulation in our academic committee, and they're basically almost the same, except that the student code of conduct is mentioned in. Ms. Swinton is the director, Title IX coordinator for student for anything involving students. And as I mentioned previously, there can never be an informal resolution with a teacher and a student. So they are very, are very much similar. But can I'll try to answer your question if you have one.
Okay, great. Thank you. I was holding off just because I know that the academic committee did not review 3.1, but we did review 14.1. So I was referring, I wanted to just refer to that which we had reviewed during the special called academic committee.
Yes, ma'am. We reviewed the HR one in the operations committee.
Right, I understand, yeah.
Okay.
So I want to first of all thank you, Ms. Walton, for discussing the plan to keep track of these complaints, because that was one of the questions that came up during the academic committee, was how would this be tracked and how will it be able to be reported out if questions such as that which John just asked. So thank you. I look forward to after you meet next week and you get everything in order to have a report on that. Ms. Cartledge, one of the questions that came out of the academic committee, though, was the use of the word grievance process. We had quite a lengthy discussion on the possible confusion that might exist when people see that the grievance process is referred to in this AR as compared to the complaint process. And you were going to look into whether or not the wording could either be clarified or if we could add verbiage to differentiate between the grievance and a complaint process. So could you just talk a little bit about that?
Yes, ma'am. And yes, and at the end of our committee meeting, I did say that I would look into it. I didn't think we'd change it. The Code of Federal Regulations requires the words grievance process, but this grievance process only is with respect to sexual harassment, as that definition is defined in 2A, 1, 2, or 3. So this process is specific to those sexual harassment allegations and complaints. So it's only with respect to what's involved with the Code of Federal Regulations. So I don't know if you all want me to add a sentence. The administrative reg tracks the language of the Code of Federal Regulations, and this deals with sexual harassment of students under Title IX and those definitions. So if you, I mean, I don't think there would, are you asking Ms. Fidrich, do you want me to, under the grievance process, the procedure, let me see here, formal complaint.
Well, Ms. Cartledge, we had a lengthy discussion during the academic committee about the possibility of the confusion of a grievance process, you know, and this particular Title IX that we looked at, and it talks and it references that grievance process. However, this is a different process. This is a complaint process, and so, you know, maybe if we could just get Ms. Walton's input on this as whether she sees that that would be a confusion. So if you look at under let me see, what is this? Is SS 14.1. If you go down to section 7, and we discussed
formal complaint pursuant to the Code of Federal Regulations.
Right, and so then you go to letter D, and it talks about include a presumption that the respondent is not responsible for the alleged conduct until a determination has been made at the conclusion of the grievance process. And so we had a conversation in committee that perhaps, you know, that wording could be confusing. Ms. Walton, do you have any concern about the confusion between the complaint process and the grievance process?
Yes, Ms. Frederick, it can be a little confusing. And I think what we need to do as we are getting into this process and trying to tweak it and make it consistent across the board, I think we need to take the student grievance and the adult grievance and put them, because they're all going to be stored together. So it really needs to be the one process, and the understanding of the difference should be from the people that manages these processes. So if we're going to have someone assigned to students and we have someone assigned to adults, then they will make the distinction as it comes into the fold in terms of a complaint. I think it needs to be complaint. I think the words needs to be consistent across the board, because if not, then you get confused, and it could really get us hemmed up in litigation if we say we thought this was one, but it really was the other. I think we just need to work internally to make this consistent with both adults and students.
And the Code of Federal Regulations mandates that the response to a formal complaint, when one of those complaints are signed and evidence is, information is provided, then we have to respond with those requirements under, it's with Title IX. These are very serious allegations that occur, so it's very specific. So we have to communicate better. We need to communicate, of course, with our staff and all, but we can't change the law of the Code of Federal Regulations. We can't change the wording, in other words.
I don't think I'm suggesting that we change the wording. I think we can get it to a point where it is consistent, even if we have to say or combine those two words together at some point.
Thank you, Ms. Walton.
We can work that out.
I think so too.
We can make it consistent.
I think so too. Thank you.
Thank you, Ms. Walton. Ms. Cartledge, I just wanted to ensure that the academic committee's concerns about the possibility of the confusion in these processes be addressed. So,
yes, and we respect that. We appreciate you bringing it to our attention too. Thank you. Thank you.
Mr. Dowling?
Thank you, Madam Chair. I share the academic committee's concern. So I'll ask the question this way. Is there going to be appropriate training or information sent out to all employees so that they don't think that any grievance at all now falls under Title IX? They're going to be seeing the word grievance under several umbrellas. And if someone is going to file a grievance against their boss for an offense that does not fall under Title IX, have to wonder. Does that make sense?
Yes, sir. And part of, Ms. Walton, and you can please contribute, but all of our staff are going to be trained.
Mr. Dowling, at this point, we do have it separated. There's a sexual harassment policy as well as there is grievance. So they're both separated now. They will continue to be separated. Yes, all employees will have to be trained. Yes, all employees will have to be notified of this new Title IX addition. So that will be separate and apart. They will also know that the grievance process, as it stands now, is not changing. This is just the sexual harassment piece.
Okay, thanks.
Thank you.
The reason I bring it up is that we're going to discuss it later in another agenda item, is that words have separate meanings to different people. And we tend to interchange terms that get people confused later on, such as policy versus administrative regulation, et cetera, et cetera. So that's why I brought it up, but that's a good answer that you gave. Thank you.
There are no further questions on this portion. Continue, Ms. Cartledge.
Yes, thank you. This is with respect to foreign exchange students, Administrative Regulation IS 58. We have revised this administrative regulation to be in compliance with the federal mandates from the U.S. Department of State and the Exchange Visitor Program. Foreign exchange students who want to come to our district on a J-1 visa, they have to be issued a J-1 visa for the Exchange Visitor Program of the U.S. Department of State. In order to be a sponsor, organization sponsoring secondary school student exchange programs shall comply with all federal requirements in the Code of Federal Regulations involving secondary school students. In number 4, the eligibility requirements are provided that are listed in the Code of Federal Regulations. I also wanted to let you know under 5 procedures for admission of eligible students, they must include a birth certificate or passport, their visa, their school transcript has to be translated to English. They have to have a current immunization record. We also listed in Roman numeral 7 about how their programs are conducted, and we have been doing these on a U.S. academic calendar year. When an exchange student comes to our school district, they cannot be employed, as a full-time or part-time. They can help with some things like babysitting or maybe some yard work. If they are eligible to participate in athletics pursuant to the requirements of the South Carolina High School League bylaws, and those are listed in their items 1 through 6. And one of the what we wanted to talk to you about, board members, is that number Roman numeral 14, given the COVID-19 pandemic and associated issues, including but not limited to consulate embassy closures, travel delays, and local, state, and federal quarantine requirements, the foreign exchange student program shall be suspended for the 2021 academic school year. And we want the foreign exchange students to come here and to be safe for their health and safety. We also want them to be able to participate in the cultural exchange. And we are not able to sponsor because of the situation that we're in right now. We don't know what's going to happen next. We won't be having any exchange students this year. I did want to let you know that I don't know who's aware of this and who isn't aware of it, but last year when the pandemic hit, it was really difficult. The Spanish embassy issued an order that all of their students had to be returned to the home country. I think it was within 72 hours. But anyway, it was really stressful for a foreign exchange student. And so we just think it's best this year that we don't have any exchange students. It's for their health and safety. And we don't know, can we be open? Will we not be open? We don't know what's going to happen next. And then just at the end there, it's updated on the legal references. So I wanted everybody to be aware of that. And this foreign exchange, we talked about it in the academic committee, and everybody gave very helpful input, and I appreciate that very much. As well as, of course, everyone in instructional services. They're really helping make these administrative regulations. They're helping to improve them and make them useful. So thank you.
Dr. Wisniewski? Could you please unmute Dr. Wisniewski?
Thank you. Yeah, I had to send a request to be unmuted. I just wanted to ask one question about if this suspension of the foreign exchange program, is that affecting any students that were, maybe in queue to come for the 2020-2021 school year?
I don't know. I haven't talked with every single principal. I do know that for Whale Branch Early College High School, that principal had already notified her particular candidates that she was not comfortable having any foreign exchange students this year. So
okay,
it's made it really hard for anybody. Dr. Wisniewski, it's been made it really hard for anybody to get over here because all those embassies were closed and all. And
no, I totally understand the rationale behind it. I just wanted to make sure that the notifications were, who was responsible for giving those notifications, how many kids might be affected by it. I was just trying to get an understanding of that part of it.
But I'll follow through with Dr. Stratus to make sure that everything's done properly.
Thank you.
Yeah, she'll make sure it's all right, and I will help her.
Bishop Fidrich?
Thank you. My question is along the same line as Dr. Wisniewski's. I wanted to find out, other than through this AR, how is our community going to find out that foreign exchange student program has been eliminated this year?
Well, we will need to contact the different organizations. We'll need to. I do know that last spring, I can't remember the name of that organization right now, but our student who was here from Spain, I had spoken with that coordinator when we received the notice from the Spanish embassy, and she had told me that day on the phone that she didn't think that there were really going to be foreign exchange students in the coming year because of the pandemic. So I think they're I think they're concerned about it too, especially when that order came out that everybody had to be returned. I mean, they don't want their students coming over there, and it was very stressful for those families having to get their students back within that 72-hour time frame. It was really difficult for everybody. It was very
Right, but as I understand this AR, Ms. Cartledge,
Yes.
students are allowed to come for as short a time period as 6 months or a semester. Is that not correct? And
Yes,
so
ma'am,
my
that is
concern-
correct. Yes.
So my concern is that come January, if there are any applications for foreign exchange students for the last semester, I just want to make sure that our local Rotaries and any of the sponsoring organizations are aware of this AR. Because I don't think it's something that normally our community reads, are some of the ARs. So how is that going to happen? Dr. Stratos, Dr. Rodriguez?
Mrs. Friedrich, I could share that. We will be sharing the AR with our school counselors. We can get the information out within our schools. Follow up, I know that Beaufort has had quite a number of foreign exchange students with some sponsoring families. We could work directly with, we do have the names of some of the sponsoring groups. We could share this information on that of what I have been made aware of, especially to the counselors who do know some of the contact families and sponsors.
Right.
We could take that approach, ma'am.
Okay, I think that would be just really helpful to get out in front of it instead of behind it.
Yes. Oh, yes. Mm-hmm. Yeah,
Thank you.
if I recall correctly, I think Ms. Robine had commented that, I'm not sure if it's a Rotary program, but a program in Hilton Head was not having students. Is that right, Ms. Robine?
That's correct. I know a friend who was going to be sponsoring a student, and she told me that that was no longer happening due to the pandemic. So I assume, that the Rotary has made that decision.
But we will follow up to make sure we communicate clearly.
Thank you.
Mrs. Friedrich, I'll send a communication now that it's been presented to the full board, to Jerry Henderson, to update her with regarding this exact Roman numeral.
Great. I think that's great. Thank you.
Thank you, ma'am.
Mr. Dowling?
Thank you, Madam Chair. I have a timeline question for Wendy Cartledge. Yeah, this is a district level decision, right? That there'll be no foreign exchange students this year. Is that correct?
Well, we talked about it within our district. We also talked about it with the academic committee, sir. Yes.
Okay.
What was in the best interest of our foreign exchange students, and that we couldn't keep them. We didn't know if we
All right. I understand that, but it's a district level decision for all schools, correct?
Yes.
Yes,
And
Mr. Dowling, this is
All right,
Dr. Rodriguez. Yes, it is a district level
Hello.
decision.
Okay. You stated that when you talked to Whale Branch High School, the principal there had already informed certain people that she was not comfortable in having. Was that prior to the decision being made at the district?
No, Mr. Dowling, that was not prior to the decision at the district. That was not. Now, in addition, I would just add that by this time last year, we had several phone calls regarding foreign exchange students and families that were interested in hosting. To my knowledge, we have not had any really this year that have come into, at least into my office.
Okay, thanks. My interest, my area of interest is that we have 6 high schools, and I want to make sure we don't have 6 different interpretations of what we're going to have for the foreign exchange program.
Treat everyone the same.
Mr. Earl Campbell?
Yes, Dr. Rodriguez. So we don't have any requests for foreign students right now.
None that I am aware of. Dr. Stratos, has your office received any?
We had earlier in springtime, Dr. Rodriguez, we did share with the contact personnel that we, subject to COVID, we want on a level of confidence of having foreign exchange for this coming year.
Okay, thank
I
you.
have not received anything since that time, to be direct with you, sir, and that was within the closure itself.
Yeah, thank you.
Dr. Rodriguez?
Yes.
Oh, your hand is up. That's why I'm
Oh,
calling.
yeah, that's because I was muted before and I couldn't unmute when the conversation had started on that topic. Sorry.
No problem. Do we have any further questions? Mr. Smith, are you participating via phone or video, sir? Video, so you can put up your hand, is that correct? Okay. All righty. So, Ms. Cartledge, does that conclude your report?
Yes, ma'am, and I thank everybody for their time, and also, hopefully we can welcome our foreign exchange students back next year when they can have a positive cultural exchange and be in school with everybody. So, thank you.
I was participating by video at this time. The video part is working, Madam Chair.
Okay, so what I'm asking you, so you can be recognized by putting up your hand, sir? Is that correct? That's what I'm asking.
Yeah, if I can get to it at an appropriate time, then yes. But it varies.
Okay. All right. Well, thank you. So we're at a little ahead of schedule. It is 9:37. So we can take a break until 10, or if Ms. Helen McFadden wants to start maybe 10 minutes early, we would have a little longer lunch. Is there any preference, or first we need to know what Ms. McFadden can do? And could you unmute her if she's in attendance?
Point of order, Madam Chair.
Yes, sir.
Since we insist on putting times on our agenda, people may be interested in tuning in at 10 for the parliamentarian in service. So I would suggest that we break and in the future stop putting times on the agenda. But for now, I think we have to adhere to what time we said we're going to be dealing with it respectfully.
All right. Any other comments? And
I'm ready at the point in time y'all tell me, whether that's 10 o'clock.
10 o'clock it is, and we'll reconvene then, and thank you.
Okay.
We're taking a recess.
Okay.
Yes, ma'am.
Mute yourself.
Huh?
Mute your phone.
Oh.
We are now reconvened. It's 10 a.m. and our speaker is Helen T. McFadden, who's a professional registered parliamentarian and a retired attorney. And she will be giving the board a parliamentarian in service for about 2 hours. And I first want to thank her for her graciousness in accepting a very late invitation because the original speaker that we had was unable to present to the board today due to a family emergency. So thank you very much, Helen McFadden, and please go ahead.
Thank you, ma'am. Before we go any further, not all copies of Robert are created equal. This is the current edition of Robert. This is the 11th edition. You can buy lots of other versions, but this is the current official version, and the 12th edition will be coming out in September. The skinny, you can see how thick this one is. The skinny versions that you can buy in your bookstore for $7.95, $10, those are the first edition reprinted, and they do not have all of the rules and all of the changes that are in this particular book. And as a matter of fact, there's a whole new chapter in the 12th edition with regard to electronic meetings, a chapter that didn't exist in the 11th one. So having said that, I'm going to see if we can move on to my presentation. There we go. Now, is that showing on your screen? Because I'm getting, okay.
Yes, ma'am.
Shared screen.
Thank you. Now, in addition to this material, which I sent to Robin to be shared with you, you should also have gotten what I think of as two other things. Let me show these to you. You should have gotten a chart that looks like this. Another chart. Are you seeing these Word documents?
No.
Okay. Then let me see. I still have screen share on. Let's see. There we go. This document.
Yes.
Yes.
Which we will use in a participation exercise. This document. And you should have gotten a version of this document, which based on our run through, we changed. And this is going to be a participatory exercise, okay? So let me go back to here and move through the basic presentation with you. These are the 7 items that are consistent across all sorts of parliamentary rules. Everything has certain notice requirements. Everything requires a quorum. Everything has a set of main and then subsidiary motions. All parliamentary authorities permit discussion and debate. All of them require voting. All of them prefer majority rule with certain exceptions. And all of the parliamentary authorities require that there be actions, that there be a record of your actions taken. Okay.
Ms.
Now,
Ms.
yes,
Robine?
ma'am.
Yeah, that PowerPoint is not showing up on our screen. I don't know if Ms. McFadden, I'm looking at it in board docs, but I don't know if she meant to be sharing that at this time.
Your Word
Thank you.
document is still up.
Oh, it is? Because it says
Yes,
I'm
ma'am.
screen sharing, and let's see. Okay. I'll just remove that one and see. Okay. Okay. That is the problem with Zoom.
Things freeze.
Yeah. Let's see.
Yep,
There you
now
go.
on your, yes, there you go.
Now we've got it. Okay.
Yep.
And I was on this slide.
Okay.
So that's all that was missed. Thank you for calling that to me. Now, because you are a public body, you are governed by the South Carolina Freedom of Information Act. That's one of the things that Mr. Dowling just brought your attention to, that you had a timed agenda that you had published under the Freedom of Information Act. And you can't vary that except within certain limitations after you've started a meeting. Because you are a public body, you've also been discussing federal laws. Federal laws, state laws, local rules all preempt Robert. If you can find the answer to your question in a state statute or a federal statute, then it doesn't matter what Robert says. The obvious conflict is that Robert permits you to change your agenda at will, to add things, to take things off, to move them around. But the South Carolina Freedom of Information Act does not permit that. You have to publish your agenda a minimum of 24 hours in advance. You have to publish it in a certain way. You have to post it where you're going to meet. You have to send it to the media, and you have to put it on your website. Okay. None of that's in Robert. And whatever the Freedom of Information Act requires in terms of parliamentary procedure is what you have to do without regard to Robert. Now, quorum, one of those first 7 things I listed, happens to be the same under Robert and under Robert and FOIA. So you have to have a quorum. You have 11 members of your board, so your quorum is always 6. If you don't have a quorum, you can only do the 3 things there at the bottom: adjourn, recess and try and get a quorum, or fix the time for the next meeting and then adjourn. You can't take any official action without a quorum present. Now, I've had the question from some public bodies, can we start the meeting? And the consensus among South Carolina lawyers is, yes, you can open the meeting. And in fact, you must open the meeting at the time stated. What you can't do is any business. You can, if your group has a prayer or an invocation or a greeting of some sort and does the Pledge of Allegiance and then receives committee reports, you can start all of that. But you can't vote on anything without a quorum. You can't do any business. You can do the passive stuff, waiting on a quorum. But if you don't get the quorum, you're going to have to adjourn or recess or set your next meeting. Does anybody have any questions on that notion?
No, there are none.
Okay. Now, there was a change in our law, Act 70, about 3 years ago. Agendas are now required for all public meetings. They have to be posted 24 hours in advance. Once the meeting has begun, you can't add anything except with a 2/3 vote and a finding of exigent circumstances. There's been one case so far on what is exigent circumstances, and our Supreme Court found, it was a Berkeley County case dealing with bonds, that the need to get the bond issue on their agenda in order to adopt the language, in order to get it on the November ballot, was not exigent circumstances. That it was a mistake they made, that the court found they made the mistake, they had plenty of time to fix it, and therefore it wasn't an emergency. Anybody got any questions on this notion?
Yes, I do, because I see here that you have written, my understanding from what you have on your slide is that the board does not have to vote on the emergency or exigent circumstance. It's the providing officer that determines that. Is that correct?
The chair makes the finding of the emergency, but it has to be approved with a 2/3 vote.
And then you also have a 2/3 vote on the item itself? So you have 2 votes? That's my question.
No, you get the 2/3 to get it on the agenda. No, I'm sorry. The final action needs 2/3 as well. I'm sorry. Yes.
So put simply, who decides whether it's emergent or exigent?
The chair makes that finding initially.
Okay.
It has to be approved by the 2/3 vote to get it on the agenda.
Okay.
For consideration.
All right, thank you.
Now, there's some talk among lawyers about this because the Freedom of Information Act refers solely to final action. So if you're not taking the final action, you're just getting it on the agenda so that you could take the final action at the next meeting if it required 2 readings. We're not sure what our court is going to say about that.
Thank you.
Okay. Now, some organizations use a consent agenda. The General Assembly has a consent agenda as part of the journal. I took a look at your rules that govern your conduct. You do not have a consent agenda rule. You certainly can develop one. It might save you time, it might not. But the rule has to create the consent agenda, determine how something gets on the consent agenda, how anything is removed from it, and how you vote on it, whether you vote each item on the consent agenda or whether you adopt the consent agenda with a single vote. So if you want to consider that, that's something you can certainly do. It may or may not work for you. Then one of the things that everybody seems to have problems with is executive sessions. Under Robert, you can do an executive session for any reason you want. This is an example of where the South Carolina Freedom of Information Act provides for only 5 reasons to going into executive session. And under current case law, there is a requirement that when a public body is going into executive session, it must tell the public which of those 5 it's going to consider in executive session. So the motion to resolve yourself into executive session is supposed to include a reference to one of these 5 things. Either you're going to do a personnel matter or a student matter, which would be number 1, or you're going to discuss a contract, number 2. You're going to discuss security matters, number 3. You're going to discuss allegations of criminal misconduct, number 4. And number 5 wouldn't usually apply to a school board. It could if you're dealing with certain tax incentives and whether or not the school district might be contributing real property. But in general, number 5 is not going to be one of the things that would cause you to go into executive session. Does anybody have any questions about these?
Mr. Dowling? Could you please unmute Mr. Dowling? Molly or Robin?
Yes, we're trying.
Thank you.
He needs. Go ahead.
Okay, thank you, Madam Chair. Ms. McFadden, I'm interested in exemption number 2.
Yes,
the
sir.
Discussion of negotiations incident to proposed contracts. Now, we quite often go into executive session to discuss the administration of an existing contract. Is that allowed under exemption number 2?
Look at the end of that number 2, position of the public agency and other adversary situations involving the assertion against the agency of a claim. And since many contracts where there is a breach of the contract or a consideration of breaching it would involve the assertion of a claim against the agency.
Okay, how about interpretation of a contract, an existing contract?
Well, again, if you're considering acting under the contract and you know that someone may have a differing opinion about how to interpret it, you're looking at creating an adversary situation involving the assertion of a claim against you as a part of a contract.
Okay, where I'm coming from is the old conundrum. Do we go into executive session because we can or because we should? That's what I'm trying to
And
discern
Mr.
around
Dowling,
contracts.
as a lawyer, I have recommended to many clients that they not go into executive session, even though they could over the particular topic. And that is a matter of your discretion. Just because you can go into executive session under this statute doesn't mean you should do it. And that's why you have to vote on it, Mr. Dowling. A majority of you have to agree that you want to say things or ask questions, ask hypotheticals about the contract that you don't want to show up later in litigation. Because anything you say in the public meeting, just like they tell you the Miranda warnings, may be used against you in a court of law.
Right. Okay, thank you very much.
Mr. Stribbins?
Thank you, Madam Chair. How specific do you have to be when you go into executive session? We've had this discussion amongst ourselves. Like a discussion of employment, do we need to say that it's executive staff versus staff? And I think one side of the argument says you should be as specific as you can without violating other statutes, and the other side says, you know, you shouldn't be too specific. Is some guidance you could give us on that?
The minimum is referencing this statute. The minimum would be to say we're going into executive session under 30-4-70 subpart 1. Okay, that's the minimum. You clearly have to do at least that much. How much more you want to do, again, it's discretionary. And what the courts have come to is you can't do it in the most general way. There has to be, if you want to take action based on your discussion in executive session, your agenda has to reflect that you may take action based on the discussion. Your agenda could in fact reflect 30-4-70 subpart 1 discussion. And you could further identify it as between personnel and student. But that's up to you. You always have some privacy concern under subpart 1, where you do not want to violate the privacy of the individual or individuals who's being discussed.
Thank you.
Okay, sir. Any other questions on this idea?
One more quick one.
Okay, hold on, Mr. Dowling. Does anybody else have
Okay.
a question, since he's already asked a question on? Okay, go ahead, Mr. Dowling.
All right. Okay. There's two cases that we've always discussed amongst ourselves, and that's Quality Towing versus North Myrtle Beach, and Donahue versus North Augusta. And it seems as though the rulings in each case were that you have to name the other party in the contract that you're going to go talk about. And if I recall correctly, the ruling on Donahue versus North Augusta was that the public, that specific intent is not satisfied if the public merely has some idea of what might be discussed in executive session.
Yes, sir. And I'm not real familiar with Donahue off the top of my head. Quality Towing generally is cited for the proposition that employees, an employee committee, is also subject to the Freedom of Information Act when that employee committee is going to be exercising the authority of the public jurisdiction. They were openly discussing the contract for how they were going to handle the towing rotation in Horry County. Now, what were the underlying facts in Donahue?
Simply that the name of the assertion that they were going to discuss a contract was too broad, and that they needed to disclose the identity of the contract.
And if you use number 2 and say, in addition to number 2, that it's involving real property as opposed to settlement of legal claims, or dealing with whether or not you're going to get yourself in a lawsuit, which is the third part of that sentence, you've given somewhat more specificity. If you talk specifically, I heard you talking earlier about the Whale Branch High School. If you were to talk specifically and say that you're going into executive session to discuss the proposed sale of the property or the proposed purchase of the property next to the Whale Branch School, you would lose your anonymity and lose your opportunity for a cheaper price. So it wouldn't be a wise choice to go that far.
Okay.
Whereas you might want to say proposed purchase and contract with a realtor. And then what you would be doing is deciding to put out bids to a realtor to purchase the property for you.
Thank you very much. I'm just concerned about saying we're going into executive session to discuss a contract. That, to me, is a very big umbrella.
Yes, sir. And do you see that if you are using item 2, you could confine it a bit more than just saying contract?
Yeah. Thank you very much.
Okay, any more questions on this?
I don't think so.
Okay. Now, because you are a school board and you have been discussing various federal regulations this morning, there are many of those federal regulations that apply higher standards to certain sorts of information. And therefore, this state statute might not be the only reason for you to go into executive session. You need to try and fit anything that comes from the federal statutes into it, but if they don't fit, you're still going to be required to maintain the privacy that is required under those federal statutes. Anybody got any questions about that?
No.
Okay. Now, another of the items of those 7 are, in Robert, it's called minutes. For you, it's records under the Freedom of Information Act. And FOIA requires that you maintain accurate minutes, requires that they be available immediately upon request, even if they are still in draft. Audit requires you to maintain your audit and budget, records of the appointments and elections, and you have a whole series of statutes that determine the periods of time that records have to be maintained by you and then maintained by others. That website down at the bottom of this slide is the South Carolina records retention spot to go to and find out what individual records have to be maintained for what period of time by you and then where they go when you don't have to maintain them anymore. There are specific retention rules under the FLSA, which is the Fair Labor Standards Act, 7 years. Your students, let's see, their GAP standards, and there are student record standards, okay? And all of those have to be maintained, as well as your minutes and budget, and as well as your elections and appointments. Anybody have any questions about your records retention that you are required to do?
Ms. Fidrich?
Thank you, Dr. Boggs. Ms. McFadden, I think one of your first statements was you talked about the minutes and the availability of it immediately. Could you just expound on that a little bit, please?
Well, here, they have to be made under 30-4-90. They have to have at least those 5 items in them. You can have more in your minutes than those 5 items, but you've got to have at least that much. And then you probably have draft minutes 48 hours or 3 days after any meeting. And there's a split of opinion on whether the draft minutes have to be turned over under FOIA or whether they have to be adopted and approved by the organization before they are subject to a Freedom of Information request. I think the better practice is permitting them marked as draft to be released when they exist. You do not have to create records, but if they already exist, they are subject to the Freedom of Information Act. And there's a requirement for retaining any electronic records.
So if I may just follow up, am I understanding you to say that when you have a board meeting, for instance, and then the minutes are they required to be in draft form on the website within 48 to 72 hours?
No,
Okay.
the FOIA does not get that specific.
Okay.
But if they exist, they are subject to a FOIA request. And you probably have a pattern or a habit of having them ready 3 to 4 days later. I don't know what your general pattern is. And like I say, there is a split of opinion, Ms. Fidrich, about whether they are subject to a Freedom of Information request in draft versus after they have been adopted at the next meeting.
Okay.
Some people say yes, some people say no. And our court has not taken a position on that yet.
Okay, thank you.
What the Freedom of Information Act does say is that the adopted minutes are supposed to be produced when somebody walks up to the desks and asks for them. Okay, now
Okay.
I am moving now into the.
Madam Chair?
Yes, sir.
Sorry, Ms. McFadden, we still have several questions. People want to
Okay,
ask.
I'm sorry.
So I'm going to just follow up. I had my hand up at the beginning with what you've just said. And so once the board approves the minutes, what's a reasonable length of time for them to be signed and become authentic or whatever?
I don't think the signing is what makes them authentic. It's the adoption.
It's the what?
It's the adoption of them.
Okay.
I don't think it's the signing of them that makes them authentic.
So what's the purpose of signing then?
I don't know. I am on the election commission in Williamsburg County, and we all sign the minutes, and I don't know. I think there's somebody somewhere that the state just has that as a habit. I
Okay.
don't know.
Mr. Strivenger?
Thank you, Madam Chair. Yeah, I agree. That signing is from a previous time. That was important back in the old days. Can you just reflect on what is the interaction between the recording of the meeting and the minutes? In other words, if people have access to the recording, does that carry the same weight as minutes?
So far, in court cases, it has not.
Okay.
The minutes are the official statement of the action completed.
Okay. Okay. So that if the minutes don't need to necessarily agree then with the recording, they are the baseline. So even if you approved minutes and that differed from the electronic recording, it's still that's the law, the minutes, not the recording.
I
think that was more rhetorical than anything.
Well, no, it's not rhetorical because it has happened.
Okay.
And it's happened with at least one group that posed that question to me. Ultimately, that group, upon discovery of the differences, amended the minutes.
Okay.
But yes, sir, right now the court cases say the minutes are it. But the minutes, frankly, just on a factual basis, the minutes shouldn't differ from what you hear on the official recording.
Yes, ma'am. Yes, ma'am. Yeah, the comprehensiveness is sometimes the question, you know. If the minutes don't reflect something that was discussed, you know, are they still good? If I'm being clear, you know, we have a lot of discussions, and obviously the minutes can't be a verbatim reflection of every discussion and everyone's opinion. So there's kind of a fuzzy area there as to what goes in the minutes. I'm just trying to clarify.
Well, the Freedom of Information Act does not require you to be the congressional record, which is verbatim. And the federal Constitution actually requires it to be verbatim. The Freedom of Information Act just says substance. So it basically means some sort of summary. Generally, you can meet that by having the text of the motions. What the electronic recording is going to tell you is all the real discussion that results in what you actually adopted. There is a provision in the Freedom of Information Act that permits a member to have something specific in the minutes upon request.
Yes, ma'am. Thank you.
Mr. Dowling?
Thank you, Madam Chair. Item number 5, any other information requested to be included by a member? Is it, correct me if I'm wrong, I believe that is not anyone's, and it's not debatable and included, correct? Not just referenced in filing cabinet. It actually becomes a part of the minutes. Is that correct?
Well, what I gave you there, Mr. Dowling, and your speech was coming and going there. Yeah. So I hope my speech is coming through to you, and you can correct me if I didn't catch everything you were saying. That phrase, any other information requested to be included by a member, is straight out of the act. Okay?
Right. Yep.
What What it doesn't tell you is whether or not the information has to be relevant to what was going on at the meeting. It doesn't really tell you whether or not it has to be in the official minutes or just an addendum to the official minutes. It's clear that a member can get specific information made a part of the record. There's been no case law on this, and so we don't really know what our court is going to say about relevance, the amount of the information. I mean, in theory, this would let you ask for the Beaufort census material from the 2020 census to be added to your minutes. And that's really kind of ridiculous.
But who would determine that?
Ultimately, a court will determine how far this goes.
Mhm. Okay.
Initially, I would say that your chair and your other members could determine that your requests were dilatory and burdensome and deny them. That's how it would get into court.
But the member would then be free to pursue the issue.
Say that again, please, sir.
If the chair or the board denied the request, the member would then be free to pursue the issue in another legal venue. Is that correct?
Right. I would suggest that the member first do what in the law is called exhaustion of administrative remedies.
Mhm.
And that might be proposing a local rule about what gets included. And then whether or not that rule is violated. But the other members have some rights in this as well. And they are going to have the final say on whether the requests are dilatory and burdensome.
Okay, thank you very much.
Since I can't see y'all, are there any other questions?
Yeah, my question was also to number 5 that Mr. Dowling just asked, and I also wanted to know relevance, because we have members requesting things that were not discussed at this meeting or not a topic at this meeting, and because of number 5, they say it can automatically be added to the minutes or as an addendum. I'm not sure if we've gotten that specific, but you've just made it clear that the board as itself could the chair and or board could vote as to whether or not it should be added. This doesn't allow a member to add anything at will.
Well, and I'm sorry, that's the tension between the words in the statute and a rule of reason.
Mm-hmm.
And our court hasn't decided that.
Yeah.
There is in parliamentary procedure, you may recall, let's see, in the United States Senate, there was maybe 2 years ago, they were in debate on something, and Senator Warren wanted to read Martin Luther King's letter from jail. And on a point of order, she was sat down because there is a general rule about not being able to read. Okay? There's a parliamentary rule that you can't read stuff. On the flip side of that, in the Senate, about 2 years earlier, Ted Cruz had been filibustering and read the entire works of Dr. Seuss into the record. And nobody stopped him. So, in fact, there was nobody there. He was filibustering. And he just read Dr. Seuss all night. It was in clear violation of the rules, and it was utterly irrelevant. Warren was asserting not only was she not in violation of the rules, but what she wanted to read was relevant to the discussion. And you see all the time people reading data when they're in debate and asking for data to be included in their remarks, even without reading it. So I think ultimately our court, once it gets to them, is going to decide that there's some sort of rule of reason here. It's got to be germane to the discussion. It can't be overly burdensome in its length and complexity. But that's an opinion as to which there is not yet any case law.
Okay, we're ready to go on.
Okay. So I'm going to move on now to the debate part of this. The role of the chair here in debate is to preside, to keep the meeting from going off the rails while not controlling the meeting. The chair is supposed to follow the agenda, maintain order and decorum, and that has to do both with the members and the public, rule on the points of order and the motion, and recognize speakers, which is what y'all have been doing all day. And you recognize them fairly, trying to alternate them, trying to give people who've not yet been heard an opportunity before folks who want a second and a third shot, okay? So the chair is responsible for the flow of the debate. Person who raised the issue has priority and recognition. You're supposed to alternate viewpoints, but that's not always possible in a small group. Chair maintains decorum and courtesy. The chair in small groups, there's a portion in Robert just about small groups, which says the chair can in fact participate in debate from the chair. You have to decide whether that's appropriate in your group. If it's not appropriate, the vice chair presides or some other member presides temporarily. And then debate can be ended either with a 2/3 vote or when it's exhausted. When the chair sees that nobody else wants to talk about it, debate's over. You should go on and vote. Now, there are the two Word documents I sent you. The main motion is always the question, what it is y'all are going to decide. Should we build a school at Carnes Crossroads? And there's only one main motion available for consideration at the time. The subsidiary motions act on the substantive main motion, and there can be multiple ones of those pending. They are in a hierarchy, and you will see from that sheet that the main motion is number 1, then amendments, secondary amendments, recess. That's the hierarchy as you move up the line. Okay. There are, and the primary thing that y'all are going to be using is amending a motion or referring it back to a committee. There are 3 types of amendments: strike, insert, or strike and insert. And the motion to substitute is a specific example of strike and insert, where you want to strike a paragraph or more, a substantial portion of it. The main motion is subject to an amendment and a secondary amendment, which is an amendment to the First Amendment. All amendments have to be germane, people talk about friendly amendments, but they're really, it's a bad practice. Either everybody's in agreement and unanimous consent adopts the so-called friendly amendment, or just vote on it. Okay? So.
Can I just ask you a question here?
Sure.
So going back to substitute, striking and inserting, you've just given an example of a lengthy motion where a paragraph was removed and something else inserted in its place. We've had 2 occasions where the entire motion has been stricken, an entire new motion put in. Can you please comment about that?
That happens all the time in the General Assembly, where the whole bill is struck and a whole new bill is inserted. So having worked for them, that's normal. The main issue is it germane? And is there anything about it that would have failed to give appropriate notice to the public about what you might do? And generally speaking, the germaneness rule will avoid any notice problems, but not always. It could be so different, but still germane, that the lack of notice is a problem. Now that's out on the theoretical edge. Any other questions?
Nope, proceed, please.
Okay. There are specific motions to postpone items that you were going to take action on and to bring them back for consideration at a later date. There's postpone to a specific time or just to the next meeting. You may be calling it carryover, but in Robert, that motion is actually called postpone. If you want to postpone it to a time certain, like to say 12 noon next Monday, that takes a 2/3 vote. If you want to postpone it just to the next meeting, that's a majority vote. Tabling under Robert does not kill something, just postpones it to a later time and can be undone by the motion to take from the table. And then reconsider is bringing something back up that you've actually adopted. You can do it obviously within the same meeting, and under Robert, you can do it until the close of the next regular meeting. It needs to, under Robert, that motion needs to be made by somebody who voted on the prevailing side. Sometimes that's the no side, sometimes that's the yes side. Anybody got questions about this?
Yes, I have another one. So it seems like table, to lay on the table, is probably misused a lot and really should be used as postpone until blah, blah. Like, for example, as I recall, this is off the top of my head, we tabled something until the AG weighed in and gave their opinion. So then when I received the opinion, I put on the next agenda, it is as a action item, because that was the action that was taken, that we were going to discuss this item again once we had the AG opinion. But that was meetings later, or a meeting later. I can't remember exactly how long. So so then there was great discussion about whether it could come off the table or not. But you've just said that it really can only be on the table for that meeting, that one meeting on which it's put on the table.
Right, and like reconsider, you can take it from the table till the end of, prior to the end of the next regular meeting.
Yeah. Okay.
But you're right. Tabling was the wrong motion for that.
Yep, thank you.
Any other questions?
I have one, sorry. So if we lay something on the table and don't touch it, don't do anything with it, does it go away?
It dies if it's not taken from the table by the end of that meeting. or the end of the next one, if you meet regularly enough. There are a whole bunch of ifs, ands, and buts about this rule.
Mr. Dowling? Could you please unmute Mr. Dowling?
Thank you. I'm sorry if I had to step away for a minute, so I'm sorry if you already covered this. I recall reading that what we do a lot is to withdraw motions, and I recall reading that in actuality you cannot withdraw a motion once it's made and seconded. You just have to postpone it and let it die. Is that correct?
You can withdraw it by majority vote at any time.
Okay,
If
but it
it's
has
been
to be
made
it has
and-
to be voted on, right?
Yeah, you can permit the withdrawal at any time
With a vote.
with a vote. Yes, sir.
Okay, thank you.
All
Any
right.
other questions?
Nope, we're ready to continue.
Okay. I've already said this, and often if you don't get back to it within the time period under Robert, you have to reach the same thing by motion to rescind. Okay. I understand from Robin that you folks are voting electronically on board votes. In essence, you're taking a roll call vote every time. I don't know how you were voting when you were present in the same room, whether you're using show of hands or a voice vote.
Show of hands.
Okay, all of those are permitted under the Freedom of Information Act. The thing that the Freedom of Information Act requires is the public vote. You can't use a ballot vote, or at least not a secret ballot vote, for anything. You could vote on a piece of paper as long as you signed it. It can't be secret. Okay. And a tie vote, always the motion fails on a tie vote, but you have to determine what's the status quo when you look at the effect of a tie vote. And then, does the chair vote? Well, on these board docs votes, the chair is voting, obviously. The chair never loses the chair's vote. Sometimes the chair does not exercise that vote in order to maintain impartiality. There was a fellow who was the chair of a 5-member county council, and he represented as many people as everybody else. And his practice was always to vote last, so as not to show what his preference was until the very end when everybody else had voted. So that's how he worked out, not failing to represent his people. He didn't want to not exercise the vote and not represent his people, but he also wanted to maintain what impartiality he could. So that's another way to do the same thing. It used to be the case in South Carolina that you couldn't meet electronically. We clearly are meeting electronically, and COVID has changed all of that. The main thing that was in the AG's opinions was that everybody had to have the ability to hear and be heard simultaneously. Okay. We know a lot more about it now than we knew a year ago. People should not, in the course of a meeting, make personal attacks on each other as members or on members of the public who are present. That is an abuse of the proceedings. That's one of the things the chair is supposed to step in and control. And then removal from a meeting, the South Carolina Attorney General has determined that as part of being a legislative body, you have the right to remove people from the meeting for disruption, basically. And you have to exercise that carefully. There are court cases in other jurisdictions, other federal cases, that make it real clear that you have to balance free speech of individuals, both members and the public, against whether or not they are abusing the proceedings before you take the step of trying to remove them from a meeting. It has to be a clear abuse, and that abuse has to be disruptive to the body continuing its business. The classic case is one out of Ohio. As soon as the member was called to task, he quit doing what he was doing and ceased the activity that was abusive. And it was determined that because he ceased right then and there from disrupting the meeting, that he could not be removed from the meeting. That was in a town council meeting. Anybody got any questions? Because this next slide is the one I want to try some of the amendment stuff with.
We have some questions. Mr. Smith, who needs to be unmuted.
Yeah, hello. Yeah. My question was back to the part when you were talking about the chair voting. Not under certain governments, if it's a coherent government and the chair does not vote under coherent government, only time the chair votes is when it's a tie. So how does that tie into Robert's Rules of Order?
Under Robert's Rules of Order, if the chair is a member of the group, the chair never loses the right to vote. And in your instance, your chair is elected just like everybody else and is representing people, and therefore never loses the right to vote.
Okay, but also what if under the governance that we're under, how does Robert Rules of Order works with the coherent governance? If the coherent governance said that the chair does not vote, then maybe is it that we should not use Robert Rules of Order? Because coherent governance may call for the chair that the only time the chair votes is when there's a tie. So it seems like that's a conflict of interest.
No.
Or could you help me understand that?
Robert does not say that the chair only votes in case of a tie.
No, that's not what I'm saying. I'm saying if coherent governance says, and if we're under coherent governance, and coherent governance states that the only time under this authority, which is coherent, a different governance than Robert Rules, and under coherent governance says the only time the chair votes is when there's a tie. Then how should we proceed?
What is coherence governance?
It's coherence governance. They didn't tell you that before you came to the meeting today that we were under coherent governance. That's our new governance.
Is that part of your policies and procedures? Where is it?
Yes, it is.
And it actually says the chair does not vote?
Did it not give you a copy of the coherent governance before coming today?
Point of order, Madam Chair, can I just for clarification, this is not a new form of governance. This governance has been our model since 2008. I just want to make sure that it's clear.
Okay, so as you'll see on our agenda for tomorrow, we're having the first reading on a policy manual that's been revised multiple times, and the governance model that we're using is called coherent governance. That's what Mr. Smith is referring to, but has been in place since 2008. And I'm unaware of anything where, quote, the chair cannot vote, unquote.
Okay.
So show the source, Mr. Smith.
The question was asked If it's said in coherent governance, and I will repeat the question and the question only, because I am not the expert at this time. The question is, if coherent governance said that the only time the chair is to vote is during a tied vote, then how should we proceed? That is my question.
Okay, here's what I understand, Mr. Smith, okay? I understand first that your present document does not deny the chair the right to vote. Is that correct?
Mr. Smith is muted.
Please unmute Mr. Smith.
Come again?
My question to you is this coherence governance that apparently is on your agenda for adoption tomorrow does not currently deny the chair the right to vote. Is that correct?
That's what I'm trying to understand. I thought that's why we were having you as the expert to explain all that to us today.
Okay. Well, I understand from your current chair that it does not. If you, Mr. Smith, were to amend it so that it does do that, then you might have an issue. But I think that the South Carolina principles of self-government, they clearly do not deny the chair who is elected the same way you were. The chair remains in the same position as you and has a full vote. If you take away the chair's vote, you have disenfranchised everybody who voted for the chair in that single member district. And you can't do that.
And that's not my purpose, but my question still remains: if the time
We can't hear you, Mr. Smith. Please start your comment again. You're still.
Can you hear me now?
We couldn't hear you at all, what you just said.
Okay, I said my question is still the same. My question is this: if under the coherent governance, if that is so, if the only time the chair is supposed to vote under the governance that we have adopted, then how should we proceed? That's my question. I mean, in regards to who the chair is, if the governance that we are under, if it says that the only time chair is supposed to is during
Okay, I understand your question to be, can we adopt some form of governance that says the chair may only vote in a tie? And I would offer you the opinion as a lawyer in South Carolina that you cannot, because the chair is an equal member of your group and cannot be denied the right to represent the constituents who elected the chair.
Let's see, Kathy.
Yes, I do not believe that coherent governance prevents the chair from voting. I have not read that anywhere, and our policies do not reflect that. We are governed by our policies.
Mr. Dowling? He needs to be unmuted.
Thank you, Madam Chair. Thank you. Am I unmuted? Okay.
Yes.
Thank you, Madam Chair. Just as a side note, coherent governance is also applied in the private sector, where it would not be a violation of law to prohibit a chair from voting. But I agree with Mrs. McFadden totally. Can't disenfranchise a member. That's not my question. My question is around abuse of meetings. If we can go back to that slide.
Let's see.
Yeah,
Here.
there we go. There we go. Okay, good. Now, this is not directed at any one individual on the board, but sometimes there are members of boards who who interpret strong disagreement as a personal attack. And the case that comes to mind is in the New York Supreme Court, where a person was a vice chairman of a school board, was stripped of his committee because he was accused of using abusive language, not profane, but tough talk. And the New York Supreme Court ruled that his language was perfectly acceptable because it was, quote, part of the rough and tumble of political discourse, end quote. So what is a personal attack? It seems to me that type of handle put on something is rather discretionary, and the right under the First Amendment is not discretionary. So how do we balance that?
Well, you've also heard, the fire in a crowded room, the issue there about public safety if there's not really a fire, okay? And so the free speech of being able to say fire anytime you want to is balanced against the crowd crushing each other trying to get out.
That's not what I'm referring to, with all due respect. That's not what I'm referring to.
I know.
I'm referring to is looking at somebody in the eye and saying, you are dead wrong.
Yeah. Personal attacks are generally, okay, not what you just said, looking at somebody and saying, you're dead wrong. But looking at somebody and saying, your mother was dead wrong about this, your father was dead wrong about this, and you're dead wrong about this. That goes beyond the just, you're dead wrong, okay? It's trying to bring in other persons who really have nothing to do with it.
Okay, so it's not necessarily if someone thinks that the person's language was a little too rough. That's not a personal attack, as long as you keep it involved with the person, right?
Well, you may make yourself open for a defamation claim if it gets too rough. I mean, it's a rule of reason, Mr. Dowling. You are right that free speech is the stronger half of this, okay? You do have the right to say what, in your opinion, needs to be said at that point in time. What you don't have the right to do is basically claim that the other person and the other person's family and is a part of this. You can't. It's hard for me to believe, Mr. Dowling, that you have a problem with this because you're asking reasonable questions.
I don't have a problem with it. I have a problem with it in many years of being on school boards, is seeing people take disagreement as a personal attack when it is not a personal attack at all. Time and time again, you disagree with someone and they say, you've insulted my integrity, and integrity never came into the conversation.
Right.
It's not a personal attack.
And you are correct.
So I just want to make sure that everyone's clear that you can't draw the definition of personal attack too broadly. That's all.
Right.
That's all.
Okay.
Thank you.
Okay. Now, I sent out Word documents that go with this slide. So I'm gonna try and get to the Word document for myself here. Here we go. Is this showing on your screen? Is there a Word document up now?
No.
No.
Okay, let's see. Well, that PowerPoint slide is probably still up. Let's see, let's get rid of that. See if, now have I got a Word document up for you?
No, we're just seeing you, not any documents.
Okay, let's see, go down, screen share and try from here. Now are you getting a document?
Yeah.
Okay, good. Now that last slide, the first one was about time, and it had the motion, I moved to change the time for our meetings from 6:30 to 7 p.m. and require that we meet at each of the high schools during the year. In theory, that's something you folks could do, okay? So I'm gonna pretend to be your chair, and I'm gonna ask Mr. Dowling, would you do number one? Would you move number one up there?
He needs to be unmuted, Mr. Dowling's. We need to unmute Mr. Dowling.
Okay, thank you.
Start
Okay.
again.
You want me to just to say number one?
Yes, sir. If we were in the same room, I would do this as an exercise, and y'all would actually do it. So
Okay.
if
All
you
right.
would say that.
I move to strike the phrase and to require that we meet at each of the high schools during the year.
Okay, is there a second?
I'll second.
Thank you. It's been moved and seconded that we strike the phrase and require that we meet at each of the high schools during the year and insert, let's see.
Oh, we didn't say insert yet.
Okay, I think it's got the wrong text. Yeah. Okay. Go back here. So all his motion is doing is striking those words. And it's got a second. And the chair would say, it's been moved and seconded to strike the phrase after 7 p.m. And if you adopt this amendment, then the main motion will become, I move to change the time for our meetings from 6:30 to 7 p.m. Is there any discussion? So the chair asks for discussion. Now, Dr. Gwatz, would you make number 2 as part of the discussion?
Number 2 under this motion on time?
Yes, ma'am.
Well, that would be another, if you
just move it, just move it.
Oh, I see, I'm sorry. I thought you were asking me the question. Okay,
No.
I'm substitute for the motion. Our meeting shall begin at 6:30 and shall end at 8:30. Meetings may continue beyond 8:30 only upon a majority vote of the board.
Okay. This member has moved to substitute for the main motion. Our meeting shall begin at 6:30 and end at 8:30 and continue only on a majority vote. I'm going to rule that motion out of order, Mr. Chair, on the grounds that it is not an amendment to the primary amendment that's already on the floor. The primary amendment is to strike and require that we meet at each of the high schools. Is there any further discussion? Hearing no discussion, let's vote. Okay, so let's assume you adopted this. And so now you adopted the strike, and there's a period after 7 p.m. And now the pending main motion is I move to change the time for our meetings from 6:30 to 7. So, Mr. Campbell, I haven't heard from you. Could I get you to make number 3?
Move that we strike high school before the word during and insert elementary schools.
Thank you, Mr. Campbell. I'm going to rule that out of order at this point in time because we've adopted the amendment to strike all of that. If you are
Right.
interested in doing that, Mr. Campbell, you would have to do a motion to insert. Okay. Now I'm going to go back to Dr. Godwitz and recognize you again. Do you wish to make your motion again, Dr. Godwitz?
Yes, I move to substitute for the motion. Our meeting shall begin at 6:30 p.m. and shall end at 8:30. Meetings may continue beyond 8:30 only upon a majority vote of the board.
Is there a second?
I'll second for
Thank you.
discussion.
Okay, it's been moved and seconded to strike and insert, strike this and insert this. So that if you adopt this motion, you would adopt a motion saying our meetings shall begin at 6:30 and end at 8:30. Meetings may continue beyond 8:30 only upon a majority vote of the board. Is there any discussion? So, let's assume this one fails. But do you understand the difference where the first time I ruled it out of order because it was dealing with this sentence here? And it wasn't dealing with a portion of this sentence. After you strike this sentence, this is all that you have. And if you vote no on this one, then you're back to this. You haven't struck it. It's now the main motion again. And you have to vote on it whether or not to adopt it. Okay. If there are not any questions about that one, I'd like to move on to this one. Ms. Robine, could I get you to move the main motion, this part right here?
Yes. I move to require at our regular meetings a set time of 30 minutes during which the parents of students may speak to the school board about their concerns.
Is there a second?
Second.
Thank you. It's been moved and seconded to require at our regular meetings a set limit of 30 minutes, during which the parents of students may speak to the school board about their concerns. Mr. Dowling, could I get you to do number 1 there?
I move to add after regular, the phrase and special.
Okay, so this is an example of a simple insert. Okay, is there a second for that?
A second.
Okay, is there any discussion?
Yes.
Okay.
I think it's too narrow. I think that we should allow other people to speak as well, not just parents.
Okay, thank you. So do you have an amendment for that?
I do.
Yes, ma'am. Can you make your amendment?
I move to add after parents of students, the phrase and members of the public.
Okay. Now, Ms. Robine, I'm going to rule your motion out of order on a temporary basis.
Yep.
Because it doesn't deal with the primary amendment.
Yep.
I appreciate your debate, and I think that after the members of the board have decided whatever they're going to decide on this, that we can come back to you. So let's assume that you defeat and special. Okay. So as the chair, I would immediately go back to Ms. Robine and say, do you wish to make your motion at this time?
Yes, I move to add after regular the phrase and special, and to add after parents of students the phrase and members of the public.
Okay, Ms. Robine, we have just defeated the and special addition. So I'm going to rule that out of order because you have just voted against that. But is there a second for Ms. Robine's motion to add the phrase and members of the public after students?
Yes, I second.
Okay, is there any discussion? Hearing none, I'll put it to a vote. And let's assume you adopt that one, okay? Because frankly, as a matter of public concern and paying taxes, the members of the public are pretty well equal to the students. But in theory, you could divide them up and have one segment for parents and one segment for members of the public, okay? Would somebody move what's right here?
I move to strike 30 and insert 20.
Okay. Is there a second? Hearing no second, that is lost for lack of a second.
Thank you.
Okay, so you're still at 30. Somebody move number 5 here.
I will. I move
Okay.
to strike 30 and insert 15 and to permit members of the public to be heard within this time limit for any item on the agenda for adoption.
Okay, now, is there a second? This time I'm going to assume the second. Okay, now, look at this. And you see how that's gotten really screwed up? Okay, so the idea behind it is okay, but the text is terrible. Okay? And it's got a new idea. It really should have included striking all of this. So if you are the chair and you see this happening, what you do is ask the maker down there who's made the insert 15, do you also mean to strike the balance of that sentence? Because if you don't have the rest of that sentence, it makes sense. That's the error that this maker has made. You see how that works? Anybody got any questions about these two?
No, ma'am.
Okay. Well, I'm sorry?
Mr. Dowling, did you put up your hand?
He has to be unmuted.
Is this the time to ask other questions on motions, or are we limiting questions right to this?
If your questions are germane to this, Mr. Dowling, I'd like to address them right now. So I really don't know.
Okay, I'll wait until there's a more germane opportunity.
Okay.
Thank you.
This is another one. You regularly have to deal with expulsions. So your main motion here is, I'm calling it student 1 rather than using the student's name. The main motion is that student 1 should be expelled from the schools of the district. Okay. Ms. Robine, would you take number 1 on this one?
Sure. Number 1 on this, okay. Mr. Chairman, prior to permitting any vote on this matter, I request that each member of this board consider whether any of them as individuals has any bias or prejudice with regard to this student or the family of this student.
Okay. Now, if this was real, you guys would know who student 1 is. Okay. And so if a member knows that some other member might have bias or prejudice for or against this student, that's what this person is doing. Asking people to examine their own conscience about bias or prejudice. And I have some information about bias and prejudice in the last 3 or 4 slides of my presentation when we go back to it. Mr. Dowling, to look at your abuse questions, notice here I'm suggesting that the member who's questioning bias and prejudice doesn't specify a member of the board, but is simply asking. This becomes a very different question and starts to deal with privacy issues for the student if the person says, Mr. Chairman, I request that Mr. Dowling consider whether he has any individual bias or prejudice with regard to this student or the student's family before we take a vote. That's getting pretty personal. That's basically asserting you've got some. On the other hand, if that member is just dead certain that you've got some prejudice, it might be appropriate to ask for an executive session simply to discuss that. And that now, assume you get to that situation and you don't have executive session on your agenda, you may be violating the Freedom of Information Act to go into executive session to discuss that. So you got a couple problems here. On the other hand, if somebody votes and the bias or prejudice comes out later, the whole vote is subject to question, and expulsions are usually litigated. So you got a whole complex of issues here to deal with just out of that one question. Okay. Could I get Ms. Friedrich to do number 2?
Sure. I move to add at the end of the sentence, quote, and referred to law enforcement, end quote.
So that is a motion to add that sentence. Is there a second?
I'll second.
Okay. Is there any discussion? And here again, assume you're dealing with an expulsion. You may not want to discuss this. You may want to just vote it up or down. Okay, but let's assume that one goes down, that it doesn't get adopted. So now you're back to the main motion as originally made. And number 4, is Mr. Geer among us? I haven't heard from him.
Yes, ma'am.
Yes, he's here.
Number 4.
I move to strike expelled from and insert it placed in school suspension, and to add at the end, so long as the student continues to make restitution to the injured person.
Okay, so that's a motion to do this and to do this. And your chair, these insert at 2 places motions, Robert tells you are not acceptable. And the real question here is, so many people do it. If you can understand it and it seems of a piece, you can permit it. Otherwise, you would make this person restate it so that it would be strike all after expelled from and insert placed in school suspension in the schools of this district, so long as the student continues to make restitution. Okay. So if you had discussion about this, and I would be inclined as chair to accept this kind of wrong amendment because it's easy to understand it. Do you see how it's easy? It flows, it really makes sense. And therefore, unlike that other one that really didn't make sense.
Doesn't make sense either.
Well,
Yeah.
it might be
I
bad
re-
policy. That's a different.
Okay.
And again, it may be bad drafting.
Well, I don't think it's clear. First of all, I mean, the language is not clear in terms of expelling from what school, remaining in what school, etc. That's a little bit clearer.
Well,
That's, yeah,
yeah, that's what it should be. Okay.
yeah.
And I agree with you. I would be reluctant to put a specific school. Again, that helps you identify the student, even though you might have 1,000 students. And so, anyway, does this one make sense?
Yes, that makes sense.
Okay. So you would vote on whether or not to strike expelled, and take this insertion. Let's assume that you adopted the amendment so that the main motion now reads, I move that student 1 shall be placed in in-school suspension so long as the student continues to make restitution to the injured person. Now, I understand that that Robin is doing these in real time for you on board docs. And so you should be able to see, as you have seen with mine, that sometimes it works and sometimes it doesn't, and you need to clean it up. So this one is now cleaned up. Let's assume you adopted the amendment, which was to strike expelled. And now you have to adopt the main motion as amended, which is that I move. So you have to have a final vote to deal with the main motion as amended. Because until you adopt the main motion, it's still subject to further amendment. Okay. Now we are closing in on 12 o'clock, so let's quit on these. And I'm gonna go back to the PowerPoint, and I would like to hear Mr. Dowling's question, if I could.
Would there be any need to define the restitution and identify who's going to enforce that?
Not in my opinion, Mr. Dowling, because the only thing, it's either got to have been ordered by a court, which is going to define it, or it's got to have been reduced to some contract. Suppose the kid set a fire and he's paying restitution to repair your school building. Y'all could have agreed with the parents as to the restitution.
Okay.
Or you could have actually prosecuted the child for the fire, and the court could have set the restitution.
Okay. I know we're pressed for time, but can I ask you 2 very quick questions? Probably a 1-word answer will do.
Sure.
Is there any such thing as a friendly amendment?
In my opinion, and Robert's opinion, no.
Okay, thank you. Secondly, is if you second a motion and saying, I'm seconding it only to allow discussion, is that prejudicial?
No, it's simply factual.
Okay, thank you.
People do it all the time.
Thank you.
Okay, that last amendment we were dealing with was you as a school board sitting as a quasi-judicial body. And whenever you're doing that, impartiality is essential, because if you are later shown to not have been impartial or to be significantly biased, it is an appealable error. So that was the point in that little exercise. You have a school board policy that defines conflict of interest, and that's consistent with Title 8 of the South Carolina Code. You don't have any policy on prejudice or bias that may be applicable to your administrative hearings, and you might want to adopt one. Bias, these are dictionary definitions. Bias is something that prevents you from being fair and impartial. Prejudice is an actual preconceived opinion, like racial prejudice or religious prejudice. And those prejudices are strong enough to lead to serious discrimination. Bias is, you like the people on your street. Prejudice is the stuff of bigger, larger movements like Jim Crow. Okay, y'all have asked me some great questions. Are there any more questions?
Mr. Mel Campbell?
No, I've take my hands down.
Okay.
All right, I'm going to ask a question, and well, I'll let others go first. Ms. Fidrich.
Thank you. Could we go back to the discussion on the slide? Issues of, I understand Mr. Dowling's point that we can't use a narrow definition of what a personal attack is, but could you speak a little bit more about it? Because my concern is that we are, that in many cases it's too narrow. And that there could definitely be a perceived personal attack. One person may perceive it when another doesn't. So could you just speak to that whole topic a little bit more?
Well, it's certainly true that one person can feel it to be a personal attack when the person who has said the words does not see it as one. And the example Mr. Dowling used was, that's dead wrong, or saying that's a stupid opinion, let's say, okay? And being called stupid is never comfortable. And if I was the chair, I would try to settle things down and say something about the stupid might be going a little far. Sometimes you have to balance that is calling more attention to it by stopping it. Sometimes it's better to move right on and get over it. But my example of calling into question members of your family is clearly outside the scope of fair debate and discussion. Sticking to the facts, even if you say that somebody's got the wrong facts or that's a stupid way to consider the facts, it might be impolite and it might be rude, but it's really not on the level of personal as saying your mother was stupid the same way. I mean, once you go to somebody's family, you've really crossed the line. That's the clearest example to me.
All right, I'm going to step in here and ask for your opinion or comments regarding this issue that happened at our last meeting. It was after, I believe, about 3.5 hours of meeting. And one board member kept going off topic. The motion on the table was referring to the academic calendar. And the chair reminded the board member multiple times that they were, off topic. And ultimately, the board member said to the chair, quote, "I just wish the chair would take her foot off my neck and let me breathe," unquote. What would you consider that? And to me, that seems, it's got a lot of problems. It's over the top. It wasn't a fair representation of what was going on. There seems to be some prejudice in that statement. There also seems to be some political, using our board as, and we're all nonpartisan members, and using our board as a political, I guess you'd say, grandstand. There's a lot of issues with that statement in my mind. I would just like your comments.
Well, first, if the member was off topic, then the chair was correct to try and move the member back to whatever the pending motion was, or the basic discussion if y'all were trying to form a motion. Because the parliamentary principle is that you should have only one thing under discussion at the time. If you try and have multiple things under discussion, you get nowhere. So first, it is the chair's duty to hold you to the one thing under discussion, whatever that may be. And whether the discussion is going on by way of debate or by way of questions about that topic, it does need to be germane. Then that particular reference is, under the current circumstances, a bit over the top. I mean, it is an assertion of a particular and specific form of violence, and it is a reference to the recent death of a man who shouldn't have died that way. And apparently, most of the country apparently has reached that conclusion. So it's a bit over the top.
Mr. Dowling?
Thank you, Madam Chair. I just have a comment, not a question. I really liked your example of the chair asking a member, did they mean to do this? To help them craft motion correctly instead of automatically declaring them out of order or the motion out of order. I thought that was terrific, and I think that's a lesson for all of us to learn in the proper guidance role of a chair.
The chair is supposed to facilitate people getting to where they want to be. And if you can see a straightforward way to get there, then you go there with help. Sometimes the only way to get there is to rule it out of order and let somebody come back with the second motion. Like in one of those, somebody said in debate that they wanted to add the thing about any parent in the district, which was appropriate. It was not appropriate to make that amendment right then and there, but it was appropriate to state it in debate and then have the chair go straight back to them after the first one had been disposed of. And a good chair can listen to you and see those things. Sometimes the chair doesn't see them exactly the way you do. Sometimes the chair makes mistakes. Nobody's perfect. Sometimes the chair makes a decision that it would be easier to rule it out of order and start over again. Sometimes it's easier to take the thing you have in front of you and fix it. And you fix it without objection. You say, would you agree that this is better fits what you're trying to do, changing the language to this? And you get unanimous consent for that. If not, you're going to have to vote for it.
Thank you. Yeah.
Do we have any other questions?
Well, I certainly appreciate your time. You've asked me some tough questions. I hope my presentation helps you.
Thank you very much for your presentation.
Thank you.
Thank you.
So we have lunch now and we'll reconvene at 12:45.
Thank you.
You're welcome. All right, we are back in session again after lunch. And our next topic on the agenda is the COVID update. Dr. Rodriguez.
Thank you, Dr. Gwads. This afternoon, during our COVID update, we will begin with a discussion on the technology plan and connectivity. And so I have with us today Mr. Mark Shahan, who will guide that discussion.
Good afternoon, Madam Chair and fellow board members. I come before you today to present the technology plan. We're going to start with our K-12 device deployment. On May 21st, 2019, the board approved the 2021 8% capital projects, which included the refresh of student devices. The board's action came after discussion in the academics and operations committees. As a result of that discussion, the refresh of devices for grades kindergarten through 2nd grade was removed from the projects list. The closure of schools due to the COVID-19 pandemic and the transition to full virtual instruction demonstrated a need for devices to be in the hands of our youngest learners. As a result, the BCSD Technology Services Division has developed a plan to accomplish the goal of placing devices in the hands of grades K through 2. And it is as follows. Kindergarten and 1st grade will be all iPads. For our 2nd grade learners, it will be a mix of iPads and our laptops. For connectivity, we're going to start off with wireless. This summer, we completed phase 3 of our wireless infrastructure upgrade project. This will allow classrooms in the district to have a robust wireless connection. The team has continued to add more outdoor wireless locations at district school sites where families can drive into parking lots and access a wireless connection. These sites are documented on the district's webpage by location with aerial photographs, which include a circled area so that the families will know exactly where to go to receive the wireless signal, and it will allow them to stay in their car while they get it. MiFi hotspots. 2,400 MiFi hotspot devices are being provided free of charge by the state and will be distributed based on eligibility as defined by the federal poverty guidelines. Eligibility requirements include income at or below 250% of federal poverty guidelines. Parents will be provided with information on the district's website and social media on how to apply for these devices. School staff will also identify families that need these devices. The district has on hand an additional 100 devices for families that may not qualify based on the state's eligibility requirements. Another 200 devices are being purchased to enhance the district's supply. The Technology Services Division will continue to monitor the inventory of these devices and expand our orders as needed. For our general update, I'm pleased to announce the staff refresh of technology. Starting off, we are refreshing our certified staff. These are our teaching professionals throughout the district. We are also refreshing classified staff. These are support staff that work directly with our teachers, families, and students, and include bilingual liaisons, our social workers, our behavior management specialists, special ed assistants, and our K through 12 teaching assistants. For support, Technology Services will be increasing the number of Tech Service Depot sites around the district from 2 during the spring to 5 for the fall during remote learning. This will allow parents and students closer access to tech supports within their communities. The sites will be Bluffton High School, Beaufort High School, Hilton Head Elementary School, Whale Branch Middle School, and the district office, giving a depot location within every cluster within our district. We are also pleased to announce our Always On Connects software that we've added to all district laptops and iPads to help facilitate software and policy updates when devices are not on district property. This was an area of need identified during the spring, and we are trying to limit the need for families to go to school sites to receive updates if they have an internet connection. For cloud updates, Technology Services is continuing to transition more IT-related services to the cloud for disaster recovery and business continuity. This summer, we moved ClassLink and our district's Google server from on-premises at the district to Microsoft's Azure cloud services. These are two key pieces of instructional software for our instructional learning device environment. And this move ensures access for staff and students, even if the district itself loses its internet connection. Does anyone have any questions?
Mr. Guyer?
Yes, Mark, thank you. Could you give me what the typical refreshed hardware that you're giving to the classified staff, teachers, and so on, specific brand, capability, for example, speed and storage capacity of the refreshed equipment that they're getting?
These are brand new HP laptops. They are coming with 8 gigs of RAM and the latest Pentium processor.
Thank you, Rob.
Mr. Earl Campbell, he needs to be unmuted.
Yes. What about those parents that doesn't have transportation to get their children to the school? What are they, what do they need to do?
Yes, sir. We are working on our plan with our transportation department to enable the ability for broken technology devices to be picked up on the bus routes being transporting our food out to our families.
So those parents that doesn't have transportation and can't get to Whale Branch Middle School, the bus will come into the community?
Yes, sir. We run bus routes daily to get food out to our students that qualify for it. And during those bus routes, those children could hand over those technology devices. That way they could come back to our depot location for repair.
Okay, and that's from K to K-12, all the way from K to 12?
Yes, sir. And one key piece is the Always On Connect software should reduce the amount of time that a lot of these parents would have to leave their house for technology problems. We identified that issue in the spring. We found that we are a very fluid environment and changes happen on a daily basis. And a lot of times we discover security needs that need to be pushed out directly to our devices. And instead of having those families have to come up to the school sites to get to our specific network, the Always On Connect software will allow a tunnel back to our environment that we can push those updates and key pieces of software remotely, limiting a lot of the need for these families to have to leave their homes.
And so that would be an iPad?
Yes, sir. For K and first grade and some second grade students, it would be an iPad. For the rest of second grade and our 3 through 12 students, it will be our standard X360 HP laptop.
Okay, that'd be a laptop.
Yes, sir.
Okay,
we are trying to shift the focus on our older students to laptops so they can develop their keyboarding skills to have them prepared for the writing requirements for our state testing.
Okay, thank you.
Yes, sir.
Ms. Orchak?
Thank you. Dr. Rodriguez, I've been asked if there'll be any more continuation of packets for those that we simply cannot reach um, electronically?
If our goal is to try to reach everybody electronically. If, as we identify individual cases that where we may have a problem with that, we will work with those individual cases.
Okay. And how do you suggest that they reach out to you? Will there be forums where you will be able to directly receive information, or are you just simply fielding them through various emails and phone calls you've been receiving? How will these folks get direction?
Yeah, so Mark, can you talk a little bit about when they have a technology concern or a technology issue, how they express that?
Generally, the first line of defense for all of our students is always their teacher. Their teacher will have contact with these students daily, and they request, our teachers have been trained in the basic troubleshooting. So if they're just having a little problem accessing one of the learning management platforms or a piece of software, they can usually help with the student or the family get the student connected. If it is a problem more intensive than the teacher can handle, the teacher will then forward that to one of our depot locations, and we're going to have technicians manning phones at those depot locations and fielding those tickets, where then they would then try to make contact by phone with those parents to help them through the problem. Our last option will always be to ask the parent to come on site and inconvenience them.
Thank you, Mark.
Ms. Robine?
Yes, you mentioned that some second graders will get iPads and some will get the laptops. Is it just because of the numbers of iPads and numbers of devices that we have, or is there a determining factor on who gets iPads and who gets laptops?
No, ma'am. It is strictly numbers. Our fleet of iPads is in need of a life cycle refresh, and they're at the age where it's not cost effective to do major repairs on them. So we are augmenting with our available laptops. We will be cognizant and try not to mix devices within schools if at all possible. We're going to try to keep the second grade at this school all one device. There may be instances where we cannot accommodate that due to the number of devices we have.
Thank you.
Mr. Scrivener?
Thank you, Madam Chair. Mark, what kind of restrictions do we have on our devices as far as access and downloading?
We are currently running IBOS content filtering, which is a requirement for our E-rate funding program. That content filter is structured to grade levels. So our elementary students would have a more stringent content filter than our middle and high school students. Those content filters look for keywords, anything from explosions to guns to bullying, all these different metrics. As it sees them, it does a nightly report, and every morning that report is forwarded out to our school principals that go through that information and disseminate it to what requirements are needed after that for discipline.
Okay, so the principals are the linchpin to making sure that we only have appropriate access.
Well, they are more on the discipline side. Technology works with instructional services to set the standards. Okay. And then we always do security standards and the basics like no porn, no gambling, no guns and violence. Those are the key metrics we look for. The reason we have our principals look over the list is because we don't know on a given day what instruction is happening in that building. That teacher could be talking about something to do with suicide. That teacher could be talking to do with something with war. That would require that kid to start doing Google searches on that content, and they could inadvertently trigger content filter blocks due to that. So we would rather our principals who are on the ground and know the content that these students are learning to make that decision, and not us armchair quarterbacking it from the district office.
Okay, thank you.
Yes, sir.
Mr. Mel Campbell?
Yeah, thank you. Now, what I'm hearing is every student will have access to some type of technology.
Yes, sir.
What I want to know is how many of those students are we cross-referencing who is going to be able to utilize them at option 1, which is internet at home, or option 2, hotspot, or whatever other options there are for those people who don't have access. Do we have any data on that on that in terms of being able to cross-reference the accesses versus the performances?
That's a very difficult question. We have been in contact with other districts around the state. It is very hard to usually determine what kind of internet access is at the child's house. We'll send out a survey and we'll ask for internet access, but they may be getting internet access through a cell phone, which might not be adequate to be able to provide bandwidth for a device in the house. In talking with other districts around the state, they are having the same problems we are. They just are not getting good data to make long-term decisions with. We are putting mechanisms in place, and we'll have forms on our website for parents that do not have internet access to be able to fill out waivers so that we can track these items, and our social workers will be working with these families to help.
Mark, can you talk about then, because the next piece to that question is, to Mr. Campbell's question is, you had communications engagement with principals to determine from the spring where they saw connectivity issues for families, and they gave you a ballpark number at each school. They gave you a number as to that, right? Can you talk a little bit about that?
Yes, sir. We are constantly doing surveys. We did 2 or 3 surveys over right before the event happened. During the event, we trying to gauge the need. We also was in communication with our schools, our principals, to get the amount of numbers that they were seeing and they thought they had. We also took that data and cross-referenced it with students that were just non-communicado and unaccounted for. So we took that number and increased it by what we thought would be adequate. We are constantly analyzing the data, and we'll be looking at it during the weeks upcoming, and we'll be very flexible to be able to facilitate the needs.
In addition, Mark, you mentioned earlier that the district had on hand 100 additional MiFi devices and a purchase now of an additional 200 MiFi devices.
Yes, sir. The original 100 was donated to us by the Pat Conroy Foundation. We are in the process with Verizon to order 200 more. And we will let the social workers and schools work with families that are right above the threshold of the poverty. Just to give you an understanding of the poverty guidelines, a family of 4 would have an annual revenue of $65,500 would qualify for the MiFi device.
And for that qualification, there are 2,400 devices available for that. In addition to those 2,400, there will be an additional 300 that the district has.
Yes, sir.
Doc, with all due respect, okay, you know how many devices you have. You know how many students are in that category of below poverty. And how does that cross-reference with what you have versus number of students? And can we find out where these students are isolated in each particular school? I mean, I hear you got 5 centers there, but what I'm trying to determine is, are those centers centrally located because of the size of the district, or they're located depending on the need of the students?
So those centers are located in each cluster, so that each
Right.
cluster to create some proximity for that need. And then the individual schools reported to Mark their identified need for kids with devices. Is that right, Mark?
That's correct, sir.
And I'm talking about connectivity devices now, right?
Yeah. Yeah, but if we can't get the devices in the hand, first of all, that defeats the purpose of the devices. But secondly, to understand who we're trying to service would make it easier to get the devices in their hand. That's all I'm saying. And I don't know how we do it. We talked about it earlier, a couple of months ago, but I still think we start that school site and get individual classroom teachers to determine who they're servicing and who they're not, and we go from there. And I mean, this is central to what we're trying to do, and some of the criticism that we have with what we're trying to do. So, I mean, it's great that we are reaching out and getting all these, devices. But on the other hand, I can't, with all due respect, Mark, I can't rely on what the other counties are doing, which may not be as resourceful as Beaufort County.
And Dr. Stratos, can you talk a little bit about the other support system in place that Ms. Swinton has?
Yes, Dr. Rodriguez. Mrs. Swinton has put together a plan, basically what we're calling a safety net, in order to start catching our students from the very onset of day 1 of school. Generally, we go through a process of reporting how many students are in attendance to see if our school's needs for teachers, and that's reported to HR. But actually, that reporting system now is going to go directly to Mrs. Swinton, and deploying the opportunity of utilizing our social workers and BMS from day 1, as well as our bilingual liaisons, to try to capture the children who haven't reported to school already, sir. That's been put in draft form. I've already approved it from 1 level. It'll be coming to the next level, and we're reaching out to our local community in order to see how we could even check into the local sites to see if our children are there as well.
Thank you.
Ms. Fidrich?
Thank you, Dr. Glods. Many of my concerns are along the same lines as Mr. Campbell, so I won't reiterate them. So let me just expound a little bit. Mark, can you share with us what is your expectation of the helpfulness of these MiFis in our very remote areas? So that's the first question, because I'm very concerned about our very remote areas in this county. And also, are these MiFis strong enough, and I know I'm not using the right technical words here, but are they strong enough so that multiple students can access the internet at the same time?
Yes, ma'am. Even no matter what we do, there are going to be some cellular pockets within the community, within our county, that are not going to have cellular service.
Right.
Unfortunately, until Congressman Claiborne's wireless survey is completed, we will not have the full effect of every piece of our county that's not covered. We do have it from a broadband perspective, but we do not have it from the wireless perspective. But we do know that there are some parts that do not have it. One item we did do is Verizon is our predominant carrier with the best service throughout our county. So we did order 2,200 devices that were Verizon centric, but we also ordered 200 from the state for the AT&T network, because we do know that there are a few pockets that have better AT&T service around the district. So we would be able to get a better idea that if that Verizon MiFi didn't work, we could possibly use the AT&T MiFi and it might have a better signal. As for the amount of bandwidth, the devices given to us from the state have the ability to service multiple children in a household.
Okay, so then Dr. Wise, may I have one more follow-up question?
Yes.
Okay, thank you. So then, Mark, I think this might then transfer over to Dr. Stratos. Dr. Stratos, what is our plan when we find out that the MiFi does not work because we're in a cell phone void area? So what is our plan at that point when the child just cannot get consistent internet to be able to participate in his or her learning?
Number one would be our communication with the school site, Mrs. Friedrich, to get the confirmation of the needs of the student. K-12 curriculum provides us the opportunity for printing instructional materials for our schools. And we could have the same opportunity with the SC virtual curriculum. We could do print screen. So those options are there, but we were trying first to do deployment of electronic. We have already prepared 16 weeks of instruction for our pre-K in hope of waiting for the transition because funding for that has been acquired as well.
Okay.
So we do have a backup plan, Mrs. Friedrich.
Okay, great. I knew you would. I just wanted to hear it. Thank you,
Yes,
Dr.
ma'am.
Stratos.
Yes, ma'am.
Thank you, Mark.
So I'm going to go to the board members that have not spoken. Dr. Wisniewski.
Thank you, Madam Chair. Yeah, my question is kind of post-deployment of the devices and once schools start. So how are we tracking and analyzing student e-learning engagement on the devices? So how are we, I believe in the spring, it was really kind of teacher self-reported. Do we have any software that's tracking that to tell us, you know, what kids are logging in, what kids aren't, how long, things of that nature?
Yes, ma'am. Our landing page, our simple sign-on landing page, ClassLink, enables us to track the online time of our students when they're logged in through ClassLink. It will also give an idea that if the student just logs in his device and walks away from it, it will let the teacher know that they were not not doing anything in that software. So it's going to be a great tool for the schools to use to better facilitate learning plans for these students.
Okay. And do we have plans, this might go to Dr. Stratos, do we have plans for those reports by school, by department, and things like that to make sure that we're really capturing all the students during their e-learning process and making sure that, you know, there are no hiccups down to the classroom level?
So there's two things, Dr. Wisniewski. One is with K-12 as well as the curriculum from the state. Principals will have that opportunity to monitor within their own house. So they can monitor utilization. That utilization ability will be at the district level. One of the things that I did as my beginning of my tenure here at the county was starting that process of monitoring software utilization. So that will continue, but it'll be in shorter increments, subject to us rolling out in a virtual platform. We do have the capability from the vendor as well from the district level.
Okay, great, thank you.
Kathy Robine.
Yes, it seems to me that a simple way that the devices have to be distributed to the families. So upon distribution, could we ask, or are you planning to ask the parents what their internet capability is? Are they going to need help? I just am really concerned that we don't want a week to go by, a week and a half to go by where the students haven't had connectivity. And if we can, set this up at the beginning when we're distributing the devices, that seems like it would be beneficial. So my question is when the devices are distributed, will those types of questions be asked?
Dr. Stratos or Dr. Bradley?
That's a great question. So we've not That's not been an expectation that we've had of principals explicitly. All of the schools are in the process of developing their own device distribution plans. I believe it's only Well Branch High School at this point who has actually started that process, and we've not asked them explicitly to ask their parents whether or not they have internet capability. I do think just that kind of naturally, if those parents don't, or if those schools are interested in obviously in gathering that information, there would probably be some exchange of information that the principals would then forward to the district, so then we could deploy our support process for those parents and families. But to your question, no, there has not been any kind of explicit direction given to principals to gather that information at the time of device distribution.
And Mrs. Robin, I will research if our registration process had in the shell that when you selected virtual, I know it may not be addressing now that we've gone district-wide e-learning, but we did put in our registration process, I believe, a question of internet capability. So I will research the confirmation of that, ma'am.
And because, Ms. Robine, because the schools, with the exception of Whale Branch, have not begun that distribution yet, that is something that that they could put in place to make that identification at this stage. So,
Thank you.
Campbell?
Yes. Those parents that income is above 65,500, would they have to pay a fee to get the instrument?
I'm sorry.
Mark, I believe he's referencing the additional devices beyond that 2,400. So he's asking if, in order to get them, if they would have a fee associated with that.
No, sir. There's not a fee associated with picking up the MiFi. There is a form that you fill out that the family would be required to fill out, stating that if they damaged it or lost it, that they would be responsible for it. And it will give some instructions that if it's stolen, that they would need to file a police report.
Okay. Dr. Stratus, what is going to be the hours of instruction?
We need to unmute Dr. Stratos.
Thank you. I don't have that exactly in front of me. Actually, I have a few emails. I have the elementary, I have the middle school. High school is doing a definitive breakdown today. I've been working with them, no disrespect, offline with them as we've been in our workshop today, sir. So I can forward that information to you.
Okay,
But we do have it and it will go out, and it has been put together by the principals, sir.
Okay, thank you very much.
Yes, sir.
All right, that looks, Dr. Wisniewski? Please unmute her.
Thank you. Sorry about that. So my question dovetails from Mr. Campbell's. So then am I correct, Dr. Stratos, in that it will be uniform times throughout the district based on whether it's elementary, middle, or high school, or will each school have, autonomy to make those decisions?
Dr. Bradley, go ahead. Can we unmute Dr. Bradley?
All right, great. Yeah, so as we were working with principals, we felt like it was really important for us to make sure that we had a consensus of principals at every level about what would be the appropriate time spans for which instruction would be delivered. I don't know what those are off the top of my head. I think Dr. Stratos has those, but we all had to make sure that there was collective input. I think this is also a really good opportunity for me to clarify something that I specifically mentioned in our virtual instruction briefing, which would be that there would be a full day's worth of instruction delivered. And as a general matter, that is the case. but there is significant autonomy that's given to the school leader and also teachers as to how that that substantive content would be delivered. Say, for example, if you have a particular a class that operates under a 90-minute block, it doesn't necessarily mean that students would be in front of their devices for the entirety of that 90 minutes. It means that you could very much have 30 minutes of direct instruction or 45 minutes of direct instruction, and the balance of that time would be for independent work. And obviously, if students finish their work before the normal course of a school day is over, then they have obviously met the expectations for that day. So I felt like it was really important to clarify that, because we did get a lot of questions. In the subsequent briefings that we have coming up, we'll also make that clear. But no, in no uncertain terms will we have students sitting in front of their devices for the entirety of a school day, because that's simply untenable, not manageable, and doesn't correspond with best practices that we know of with regard to the delivery of virtual instruction.
Thank you very much. And Madam Chair, one follow-up question, please.
Go ahead.
My follow-up question was, when do we anticipate, getting that out to parents so that they know what those days are going to look like? Dr. Stratus said she didn't have it right there, but I was wondering, when we were anticipating releasing that information.
Dr. Wisniewski, we have for the elementary as well as the middle school. High school is working on that right now.
Okay.
We could get it out to Candace. I think the preference, and I don't want to speak for Dr. Bradley, but they want to deploy it all simultaneously.
There, Dr. Wisniewski, I think it's also important to note that there is some measure of flexibility in terms of the expectations that we have for students. So there obviously is a state attendance requirement, but we know that, for example, if elementary principals have decided that they want their students to log on to their devices at 8:30 every morning, that in some instances that might be a challenge for parents and families who are having to work from home or have other responsibilities. So in K-12 Learning Solutions in particular, there is a recording device where students can kind of get on their device, get their lesson, complete their assignments, and then principals or teachers can still count them present for the day. So there is a measure of flexibility built into our virtual learning process.
Okay. Regarding those recordings, are they continually recording so that the kid can log in at any time and start accessing from the beginning, or do they have to wait until that time period or that lesson has completed?
I'm not sure, Dr. Stratos?
Yeah, I'm trying to get clarity at the question. So I know they are recorded and stored, that you could pull them up, or may the student step in?
Oops,
We can't hear you.
Yeah, can we unmute Dr. Stratos again?
Thank you. So, Dr. Wisniewski, is the question with regard, as instruction's happening, may I step into the classroom like a tardy, and if it was a live classroom?
Sort of. I'm wondering if, say the class starts at 8:30, but the child's not able to log in until 8:45. Are they able to begin that recording from when it began at 8:30, not necessarily come in halfway through?
I think the option is going to be up to the student. They will have to report to class as if I'm late and go back up, and then the teacher can go into a breakout room, because we do have the capability to break out rooms as well. So I haven't seen to the level of that question of I could deploy that recording in the breakout room, but as it's simultaneously recording.
Got it. Yeah, it's what my
that's a good one though, because I'm going to ask them. I will ask. Because
nice.
we're
I don't know if it's a capability.
No, right. I don't know if they have the capability, but I will ask, because we're asking them to stop recording it, almost like we do with our televisions. So I will inquire.
Thank you, ma'am.
Yes, ma'am.
Ms. Orshak?
Dr. Rodriguez, is there any aspect of your update presentations today that will focus on our special needs students?
That portion we're going to be covering on Tuesday's COVID update.
Thank you.
And Ms. Orshak, let me also add that there are a series of briefings that we have planned, and when I say briefing, I'm referencing the style briefing that I delivered a couple of weeks ago. And the next one up that we have is for special ed students. And so we're going to be releasing that one next week. And I'm saying that as a general matter, not just for the board, but for all of our guests who are listening in today, because we recognize that there have been a lot of questions that we've had over the past couple of weeks about how specifically we're going to be able to address the needs of our special needs students. So that's coming up next week.
Thank you.
Yes, ma'am.
So Dr. Rodriguez, we have about 5 minutes to wrap this up.
Okay. Well, we got two items. So the next one on the agenda is, I'll take this one very quickly. It's related to the state letter that we received. And on the state letter that we received, Molly Spearman sent on Wednesday, I believe it was, on August 12th, that they changed that contingency of September 14th, that every 2 weeks after a school district's start date, they would review and jointly evaluate with the school district the metrics with the goal of obviously returning to a face-to-face instruction. So I think that would be an every 2 week conversation with the state, 2 weeks after September 8th start date. So the specifics about what that joint evaluation or meetings, I don't have that. That hasn't been provided as of yet. I'm just confirming for you and for our community that September 8th start date, and then every 2 weeks would be evaluated with the state. The next piece on the update is regarding athletics, and Mr. Otting, are you on?
I had a question.
Yeah, hold on a second.
Yep, there I am. Can you hear me now?
Yes.
Okay. Would you like to ask your question before I begin?
No, go ahead with your presentation. We have just a few minutes and then we'll have time for some questions again.
Okay, I will try to be brief. Then I just want to let everyone know that athletic tryouts begin on Monday. We are following the guidance of the South Carolina High School League, and they have set up a schedule. And that schedule is a staggered schedule based on sports, with low risk sports beginning their first day of practice on August 17th, which is Monday. So that includes golf, swim, and girls tennis. And then the moderate risk sports begin August 24th, which would be cross country and volleyball. And then the higher risk sports, they do not begin practice until September 8th. Now they can begin workouts on August 17th. And those workouts have some restrictions, but in the interest of time, I will stop right there and answer any questions. And the lead AD, Carlos Cave, is on the line as well. So he may, if you have a question that regarding kind of the procedure of South Carolina High School League, he can answer those as well.
Mr. Earl Campbell?
Yes. Robert, can you send me a copy of those dates and the sports that you're talking about?
Yes, sir. I'll be glad to do that. I'll send you an email. If Robin would like, I'll send it to Robin so she can send it to all board members.
Okay.
Exactly. Thank you.
Madam Chair.
Yes.
I had got to ask Dr. Rodriguez when you talking about the letter from Molly Spellman. What if once the rate goes down to 10%, would that mean that we will go face to face?
So the metrics that we've been using are the DHEC metrics. That falls in line with what those metrics would show. That would be a drop from a high category to the medium category, right? And which is the stable category. And I believe that is what the state is going to be requiring for districts, but I don't have that specific yet because they haven't provided any additional information about that.
Thank you.
Yeah.
Dr. Wisniewski?
Yes, can you hear me?
Yes.
Yes.
Good, thank you. So I'm sure my fellow board members and the public are aware. If not, I will catch everybody up to speed that as recently as last week, I solicited in feedback from parents regarding the reopening plans of the district. I was concerned about some of our vulnerable populations, and I wanted to hear directly from parents, hear their testimonies and what they were, facing right now, because I hadn't heard honestly from many of them, but I had heard from some. So the response was relatively overwhelming, to say the least. Some of the stories are upsetting to hear. So at this time, I'd like to have a conversation surrounding the potential for a face-to-face option on September 8th, especially for those vulnerable populations. And if I need to make a motion, I will.
Well,
I was told that it was on topic and that
Yes.
I was allowed to bring it during the COVID update.
yes, so why don't you make a motion?
Okay. I move that the Board of Education direct the superintendent to move forward with the virtual and face-to-face reopening options on September 8th.
Do we have a second?
Second for discussion.
Okay, so Robin, can you put that in the,
Do you need me to repeat it, Robin, or I can put it in the
or
chat
can you put it in
box?
the chat? Yeah.
Yeah,
If you put it in the chat, and I am working on it.
it's in the chat box, Robin.
Got it.
Thank you. And I would like to make a statement as well. I made a previous statement at our August 4th meeting that I deeply respect Dr. Rodriguez, and I appreciate all the thought and effort that the staff has been putting into these reopening plans. And if I didn't have confidence in the face-to-face reopening plan that he put forward, that had multiple different protective measures for students and staff, I would not be pursuing this, but I am confident in that plan. And I think they did a fantastic job doing it.
Who seconded the motion?
I did.
Okay, thank you.
Mr. Mel Campbell?
Yeah, I didn't think we finished the last topic, but my question is about the athletics. High school league has a certain amount of.
I think, Mel, I hate to say this to you, but because we have this motion now on the table, we'll have to have your question come after this.
That's why I said it was off topic when she came with her motion. When we were still on that topic, and I asked, whether she was advancing the topic, and you went on with the motion, but okay.
Okay. Ms. Orshak?
Thank you. There seems to be some confusion in our community about the communications coming down from Ms. Spearman, and I have to admit I'm a little confused myself. When our state superintendent of schools, Ms. Spearman, says you must include, a face-to-face or a hybrid model in your plan, is she saying, one, that you simply have to include it in your documentation but don't have to activate it? Or is she saying that, two, not only does it have to be included and laid out and spelled out in your plan, but you actually have to utilize it and put it into play? So there's a little bit of confusion about what that means when she says this has to be part of your plan. Is it just in writing, or do we have to implement it per Dr. Wisniewski's motion on the floor?
So my interpretation, Ms. Orshak, is that there's a plan that's submitted, but but the State Department of Education understands that there are, things are different in different places across the state, right? For example, many districts shifted their start date, as did we, right? Other districts have different levels of infection rate, right? I mean, so right now the whole state is looks like it's high, but there might be different levels within each county, right? And so I think what her letter is saying is that understanding that there are differences within the counties and understanding that there are different start dates, right? That a September 14th contingency date didn't match for everybody, right? And so I think what they shifted was to 2 weeks after the start date of the school system, right? And then I think that additionally, their intent with the 2-week monitoring is that school districts are looking to move and implement that face-to-face component, right? And the purpose for the evaluation every 2 weeks is to see what the current circumstances. But I believe, we don't have the clarification yet, but I believe that that's the intent, and that their intent is to move districts towards face-to-face implementation.
Yeah, and I understand that to be the ultimate goal, but I do think that perhaps our state superintendent of schools can be a bit more clear to provide some additional verbiage that says, yes, we definitely want a written component in your plan that speaks to how you would do a face-to-face opening or eventual opening. However, we are not demanding that you put it into play by a certain date or a certain point on the timeline. That clarification is really not there, and it leaves it wide open to confusion and misinterpretation is the feedback I'm receiving, and personally I'm not clear on it. So, and Dr. Rodriguez, it sounds like you're trying to interpret on using your own means.
I think
we need to have our superintendent of schools be a bit more clear on that, I think.
I think I have. I think the first part of what you were saying, Ms. Orszak, about the plans was that they wanted school districts to provide a plan that had a virtual option and then a face-to-face option, right? But what several other school districts, found themselves in the situation with the metrics being as high as they were and going in the high direction, that even though their plan had a virtual option and a face-to-face option, right, that they determined that it was best to begin all virtual given their circumstance. And I think that then led to this subsequent letter for school districts. But there's a second half to your question that I don't know the specific yet.
But it confuses me because we've always had, when we submitted our plan on July 17th, we did have an outline of an in-person option. So I'm very confused with her follow-up letter. It was already in there. I don't understand what the follow-up letter is really saying, I guess.
I think the follow-up letter is based on the fact that we have opted to begin everyone face-to-face. I'm sorry, everyone virtual.
Virtual, okay.
Right.
Now, the hybrid model was inserted. Was that without your notification? That post to the state website happened days prior to you formally being notified by letter. So was that done without your understanding the addition of that third option?
Well, I'm not sure what you're saying about the hybrid option inserted.
Okay. there was a screenshot widely circulated on social media that was taken directly from the State Department of Ed website. And I believe Dr. Wisniewski circulated it as well. Is that correct, Rachel?
Yeah, I went to the State Department website and pulled it up on my phone. I think another member of the community also did. I saw it happen in a different county, had the same stipulation attached to their plan. So that's why I went back and looked at ours and saw that ours changed too. So
And this was the screenshot, the letter that was sent?
No.
No, sir. No, it was when you go to the Department of Ed website, you pull up the plans, it has that little bold and asterisk where it says what the state superintendent's stipulation was. And it talks about that. It used to say September 14th, and now it says every 2 weeks.
Okay, which is what the letter says.
Right.
Yeah.
There's also a third option as opposed to just virtual and just in person. There was the addition, is this correct, Dr. Wisniewski, of a third option, which was a hybrid?
I think hybrid was always a part of the original plan due to us having some schools that may have to go hybrid due to their population. I think that was already there.
All right, my mistake. I thought that was added without the district being notified of it in advance.
Mr. Dowling?
Thank you, Madam Chair. Dr. Rodriguez, just a couple of questions, yes or no? Based on the data, is it safe for people to have face-to-face, in your opinion, as superintendent?
Right now, the metrics are high, Mr. Dowling.
Yes,
and
yes or no?
Sir, I'm just going to explain to you the metrics are high, and that's what I see. We opted to start virtual because they were high and continuing to go high, and we have students and employees in that consideration. So because they were double the number that it would be and percent positive to get to the medium category, and they were at the time triple the number that it would take in incident rate to get to the medium category.
So I gather from what you're saying, you don't feel it's safe to have face-to-face.
I think there's greater risks for employees and for students with the higher infection rate.
Okay. All right. Thank you. But fellow board members, I do not believe that one student or one staff member should be put at risk while we're in a high risk quadrant on the report. We cannot have this decided by plebiscite, that more parents want this or less parents want that. One child, one staff member sick and perhaps dead is too much of a risk. And I implore you to consider that, and also consider that we put Dr. Rodriguez in charge operationally for the district. He has made a determination, and the superintendent of schools for the state, Ms. Spearman, apparently agrees with him that we can take it on a every 2-week basis to see how the data matches up to where the data is now. We cannot have on our conscience a moment of silence that we could have avoided. We must not vote for this. We must keep the decision in the superintendent's hands. I will vote no.
Mr. Earl Campbell?
Yes, I just want to make a statement. I think the State Department has most districts confused, because if DX says that is the metric is high, I think Beaufort County is what, 20.9, and to have face to face, you don't have to be down to 10. So I think that's the State Department has to make up their mind what they're going to do.
Ms. Fidrich?
Thank you, Dr. Glatz. Dr. Wisniewski, if I heard you correctly, you started out this afternoon by saying that the reason that you reached out to your constituents or the population is your concern for our most vulnerable population. Is that correct?
Yes, ma'am.
So I'm just wondering if this is not a bit premature, since Dr. Bradley suggested that by next week, we would have a plan or some type of process or notice about what the district's plan is to help our students with special needs. So, it sounds like that is in the works because of the multiple number of parents that have reached out about their concerns for our students with special needs. So I'm just wondering if this might be a bit premature.
No, I can definitely appreciate that. And I'm glad to hear that there will be something coming forward to those individuals. But when I mention vulnerable populations, while I am definitely including our SPED population, I also mean ESL, our children that are food insecure, our children that are homeless, our children that are in a single parent household. And I've been contacted by, I can't tell you how many, and said that if virtual is their only option, they will likely have to quit their jobs, possibly lose their homes, and not be able to put food on the table. So when I hear stories like that from people, that really pulls me to action sooner rather than later. And that concerns me to hear that. So I understand the concern that this might be premature, but I think that the earlier the better, just like we announced, or Superintendent Rodriguez announced the virtual plan sooner so that people could plan for that.
Perhaps then just by you stating what you include in the vulnerable population, perhaps Dr. Rodriguez, perhaps Dr. Bradley, or someone could also look into what our ESOL population and some of the other areas that Dr. Wisniewski mentioned.
Okay.
Mr. Stribinger?
Thank you, Madam Chair. Just so I understand, the superintendent made a decision, and we are now asking him to reverse. This motion is asking for him to reverse that decision. I don't think that's a smart thing to do. I'm also somewhat shocked that I haven't heard any coherent governance lecturing. But I can't vote for this because I think the superintendent made the decision. We're moving forward. It's going to be reevaluated every 2 weeks based on the statistics of risk. So I can't support this.
Colonel Guyer?
I can't support this because I'm concerned about the rest of the at-risk population in this county. When I went to graduation this year, and we had it in the auditoriums, and I saw family members coming forth to congratulate their graduates, I saw a great number of at-risk family members that came up to take pictures of their graduate. And those are the family members who could receive the virus from a student in our school if we open up face-to-face instruction. So I have a concern of that at-risk population, and I cannot and will not support that, as well as at-risk populations of our teachers. And if you look at the numbers of our teachers that are at risk and have family members who are at risk, high risk for this pandemic, it's irresponsible to open it up until the infectious rate drops down to a level which DHEC says that the risk is acceptable. It is not acceptable now, and we don't know when it will become acceptable. So I can't support this.
Madam Chair, if I may respond.
We got some other people in the queue still. So, Mr. Melvin Campbell, do you want to speak to the motion? I know you want to speak to the other item, but.
Yes, I want to speak to the motion. Thank you.
You're welcome.
I don't know how to respond to the motion except that we've vetted the numbers. we've agreed with Dr. Rodriguez in terms of the numbers. I mean, the selected population, in order to service them, I think we need outside resources. I haven't heard anything from the federal government or the state in terms of the special ed resources that's needed to really service those individual students. And, you know, over a month ago, we talked about the plan. Everybody wanted the plan. Dr. Rodriguez was struggling at that time with developing a plan that would service. Then when he came up with the plan, you guys said you really wanted that plan. Now we're questioning the plan. Well, we can't execute a plan if we keep changing the plan. You know, one of the big critics about the virtual is that it wasn't planned well and we didn't do well with it. Now we're asking us to switch with a few weeks to go back into open when we've all gone past that. We've all gone away from open to really focusing on making virtual work. And, you know, being a former classroom teacher, I wouldn't, you know, particularly appreciate if the superintendent came to me next week and said, now we're going back to open versus virtual. And I don't know how parents adjust to that. But all of the parents, and I understand, I'm sensitive to their needs. All the parents should begin to make adjustments. This is not your normal time. We can't have what we want. We have to have what's good for the children. And in my mind, the children are the most important element of the whole deal. I don't think one parent would sacrifice a child for the fact that they didn't get a college education because they missed a year of COVID-19, as opposed to not having the child at all at 19-year-olds. That's the kind of consideration that families have to make, that kind of decision now. And you know, that I can't understand why we're having this conversation.
I have not spoken either, and I can't support this either for many of the reasons already given, so I don't think I'll repeat them all, but basically the most important ones are, you know, it's within the purview of the superintendent to determine how schools should open, and certainly he has very carefully researched this, and he's also has some obviously direction from the State Department of Schools, and I think he's done a very good job, and it's extremely hard to do this. And the board majority approved the position he took on August 4th, and the metrics remain high. That is not any different. It's going to be reevaluated on every 2-week basis, which is important. And I think we all agree that face-to-face, in-person learning is what we're shooting for. That's the long-term goal, to have that as soon as it is safe. So I cannot support this. And I think people are unrealistic to think that we can open the schools and face-to-face is going to be with some, you know, safety restrictions going to be similar to the way it has been in the past. It's not. People are going to be infected. The students are going to have to, or the teacher is going to have to then go to quarantine for 2 weeks. I mean, that's going to be so disruptive. It's disruptive. No question it's disruptive. And I think this is the best, that Dr. Rodriguez has come up with the best option for September 8th. So do we have anybody that's going to speak to something that has not been already addressed with this?
Yes. Yes.
Okay, so okay.
Yes.
Orshak's first.
Okay, couple things. I don't believe Dr. Wisniewski's intentions are less for our children than the rest of us. I think she's speaking for half of the population who wants answers. So there's that. Also, I'm going to be consistent and abstain with this vote for the same reason I abstained to Mr. Stribinger's motion at our last meeting to support the superintendent's decision. I believe it is in fact his decision, and these superfluous motions to either approve or change are really unnecessary. So there's your lecture Mr. Strivenger on coherent governance. But really, mine is a process question, Madam Chair. Okay, at our last meeting, the board voted to support, AKA approve, if you will, the superintendent's decision, which was very different at that time. It was solely to open our schools electronically, virtually. This is a motion that was put on the floor today by a member of the board who voted against that past motion. So can you please tell us what the correct process is today?
Well, I think it depends on how you interpret the motion from the last meeting.
We have the motion for review. The wording of it.
Rorschach, let me just say this in the interest of time. We debated that back and forth and we didn't come to agreement with it at that time. So I don't think we'll come to agreement with it now today in our work session.
This is a process question, Madam Chair. I'm not certain the motion on the floor is out of order.
You are out of order. I'm trying to
Call for the question.
call for the question, okay? Yep, let's call.
Madam Chair, the motion on the floor is out of order. Would you please deal with it appropriately as chair?
You won't let me answer.
The motion
for
is
the
out of
question.
order, Madam Chair. Please deal with it appropriately.
The
as
board,
chair.
the board will decide. So let's call for the question, please.
Madam Chair, point of order, that is not what I'm asking.
Said
You
call
are
for the
chair
question.
and you can rule on this matter. I believe the motion on the floor is out of order. Can you please rule on it?
I'm giving my answer, but you don't let me finish. My answer is, when we voted on August 4th, we could not come to agreement the exact meaning of the motion. Some of us felt, it seemed like the prevailing side felt that it was just validating the superintendent's position. It was not saying that we made that decision. I believe you had the thought that because we voted to support his decision, you interpreted that to mean that we therefore made that decision. It was something along those lines. So since we don't agree on what that meant, that is why I will not rule this out of order. I think the board should vote. I don't think it should be my decision. I'm not going to take that. I'm going to have the board vote. You can vote
Madam
however.
Chair, call for the question, please.
Call for the question. Yep, we're voting now.
Point of order, point of order, point of order,
Voting.
please.
Voting is open.
Point of order.
Mr. Dowling.
Thank you. I challenge Mr. Campbell's eligibility to call the question. That is a matter for the chair. And also, Madam Chair, you said, does anybody have anything to say that hadn't been said yet? I do. And
Okay.
thirdly, if we didn't understand the meaning of that motion on August 4th, why did we vote for it? It astounds me. Anyway, if anybody needs further proof that it's not safe, look at the track record of the districts in neighboring states that have opened already. It's dismal.
Okay,
Nobody.
so Mr. Dowling, we're gonna take a 2/3 majority vote to call for the question. Since Mr. Earl Campbell called for that, we can do that now. So
Okay.
Miss Robin Cushingberry, the motion, the vote right now is for 2/3 to end the debate. So all those in favor of ending debate, please raise your hand and do it just in the screen if you're going to end debate. And let's just go district 1 to 11, yes and no. Well, how about, let's just, because I can't see everybody's face.
8 to 1.
Are you asking for a roll call, Madam Chair?
Yes, but I can't see everybody. That's the problem. So, Earl Campbell, yes or no? Yes, right?
To call for the question?
Yes, call for the
Yes,
question.
yes, I'm saying yes.
Okay, next person in line, number 2, who's next? We'll just go down. Mel Campbell,
Yes.
David Strebender.
He has to be unmuted.
Mute. Mute them all.
Yeah, David?
Say yes.
He needs to be unmuted.
He raised his hand.
Yeah.
Okay.
Can somebody unmute him?
We're trying.
Ms. Orshak? Yes or no?
District 11, call for the question, yes.
Dr. Wisniewski?
District 7, Wisniewski, no. I had my hand raised and I was not recognized.
Mr. Geyer?
Yes.
Christina Guadz, yes. Is Mr. Smith here? Kathy Robine?
Yes.
Tricia Fidrich?
Yes.
Let's see, John Dowling, I don't think I have, yeah, have you? Yes?
Yes, yes.
We're trying to unmute William. He has to unmute himself.
David, you're unmuted now?
Yes, ma'am.
Yes or no? The call for the question?
Oh, yes, I'm calling for the question, yes.
All right. Can we hear Mr. Smith now? Yes or no?
No, he's gone now.
Okay. All right. So the motion carries 9-1 and not voting. So 9 yeses and the 1 no is Rachel, and Mr. Smith did not vote. So please go ahead and go into board docs.
Hold on, I have to reset it then.
Okay.
Voting's open.
Dowling votes no.
Orshak abstains. It's the superintendent's decision.
Mr. Earl Campbell,
No.
Mr. Melvin Campbell,
No.
got it. I have to see if Mr. Smith came back in. I don't see Mr. Smith, so I'm putting a vote not cast.
Thank you. The motion fails 1-8-1, 1 vote not cast. Yes, Wisniewski, and the 1 abstention, Ms. Orshak, and Mr. Smith not cast. So now we can go to Mr. Mel Campbell's question that was not on this.
Yeah, my question was about the high school league versus the district's autonomy. Do we have the option of having a football team or not having a football team on the field as district schools? Or do we have to do what the high school league regulates? And if the answer is no, we don't have to have a football team on the field, then my question is, why are we having a football team on the field when we can't have open classrooms?
Mr. Campbell, on that, I would have to inquire more about that. I don't know the specific answer to that question in terms of membership in the high school league and then participation in that end. So I'd have to inquire more about that.
Okay, because I think that's essential to the safety of, of the students we're saying we want to keep safe. You're going to hand-to-hand battle in football. That's much more dangerous than sitting 6 feet away in a classroom with a mask on, in my mind. I really think we should not have football.
Dr. Wisniewski?
I do know that is, Mr. Campbell, an ongoing evaluation of the high school league, and they may not. They may not. They're continuing to do that.
But even if they do you have the autonomy to say no? You don't want to field a football team. That's the other question.
Yes, and we'll follow up on that.
Yeah, thank you.
Dr. Wisniewski?
Thank you. On what day is the plan to release the special education information for the virtual option to families? What day is that?
Dr. Bradley, can you unmute Dr. Bradley?
I'm so sorry for that. I was trying to get unmuted. Thursday.
Thursday.
Yes,
okay.
ma'am.
So if I may ask this question, I don't know if you already have the answer or not. For SPED families, ESL families, those that don't have internet capability, any of that, is there any plans to provide in-person instruction to those that virtual will not work for?
So there has been some discussion, and as recently as last Monday during our senior staff meeting, to explore the possibility of bringing our students who have severe and profound disabilities into our buildings. We have directed Dr. White, who is our Director of Special Education, to number one, gather a full and complete list of the number of students within our district who currently suffer from severe and profound disabilities. And then secondly, to get some sense from our special education teachers who serve specifically that population of children on their willingness to actually come into the buildings. And then once we have those numbers, we will present that option to Dr. Rodriguez and also to senior staff for evaluation as to whether or not we can actually successfully implement that.
Okay, so at this time, we don't know if we can service the SPED students face-to-face.
Well, not all categories of special education students. We're talking, I was referring specifically to those students who, by designation of their IEPs, to have severe and profound disabilities, which by percentage is a much smaller population than our general special education population. So we don't know at the moment. We are looking, first of all, at our current numbers, and then also at the numbers of teachers that we have that are willing to come into buildings. And I say that because there was a general thought that we would not be able to serve them at a high level in a virtual format. And so if there was obviously a manageable and controllable number of students that we could bring into the building and had teachers that could serve them, that was something that we were going to present for recommendation.
Okay, and is there going to be a specific presentation or forums, what have you, for the ESL population?
I'm sorry, say that one more time, please.
Is there going to be a similar presentation for ESL students?
Yes, there was the briefing, if I'm not mistaken, that will follow special education will be specifically for ESL as well.
Okay, and how are we disseminating that information to that population?
So obviously through our websites, we have activated or directed our principals to make sure that they are in direct and regular correspondence with their parents and families with weekly updates. And then I think we also have internal personnel that will help to facilitate a forum or a briefing in the same spirit of as the virtual briefing that we conducted last week, that will be in both English and Spanish.
Additionally, I'm connecting with La Isla magazine that's doing Facebook Lives and has a large outreach in certainly in the Hispanic community.
Okay, thank you. That was another component I was going to ask about. And then one last question. So since the announcement of moving fully virtual, how many students have we had withdraw from the district?
I don't have a list of how many have withdrawn from the district. I can tell you, I believe we're right around 18,000 registrations at this juncture that we've seen. I believe that was yesterday afternoon, I think.
Okay, so we have about 18,000 registered for virtual option, and
not virtual, just complete, both, everything. Yeah, registered with us face-to-face and virtual, because we're still registering that way, right? Because some families, even after it's safe to return to face-to-face and we return to face-to-face, some families may want to stay virtual.
Right.
So.
And we've still not issued a registration deadline yet either.
Okay. The main reason why I was asking that is because I had heard from some people that when they heard that we were moving fully virtual and they had chosen the face-to-face option or virtual, that they decided they were just going to go do their own thing. So I'd heard that from quite a few people. So if you happen to get those numbers of who's formally withdrawn from the district and can send them to me, I would greatly appreciate it.
Yes, we'll do.
Mr. Earl Campbell?
Yes, I was going to make a comment. See if Coach Cave have any comments about athletics.
Yes, Mr. Campbell. Representing Beaufort County as lead athletic director, I also serve on the executive committee. The executive committee is the ruling approval committee for all South Carolina High School League regs. The High School League has submitted guidelines throughout the course of this summer pertaining to athletics. Currently, South Carolina, we're operating under phase 1.5 in athletic guidelines, which has a host of safety and sanitary guidelines based on CDC, DHEC, and SDE, meaning the State Department of Education. So these guidelines have been vetted and put in place, not just by the league, because I also serve on the Return to Play committee with the South Carolina High School League. So we also have input of medical as well, dealing with the guidelines that have been put out. On the 17th, which has already been stated, fall sports around the state of South Carolina can begin on that date with the sports that have been stated, that being girls tennis, girls golf, and swim. They then have a staggered start for volleyball and cross country beginning a week later, and then your high risk sports of football and competitive cheer. Obviously, because of proximity and social distancing, those things that factor into football and competitive cheer, they fall into the category of high risk. The High School League and the Executive Committee, based on recommendations from the Commissioner, Jerome Singleton, will be updating us as Executive Committee members on metrics as they change and advise and put out advisories based on those metrics for us to approve as Executive Committee. As it stands right now, the recommendation that has been put out aligns based on the information that was presented to the commissioners and then voted on by members of the Executive Committee. I'm saying all that to say that right now, I think that the information that I've received that we're going to align as a district with the guidance of the South Carolina High School League, but the district does have options, and I know Dr. Rodriguez will pursue, and he'll vet those options. But the league is also closely monitoring and seeing if changes need to be made in any sport with the possibility of moving sports seasons around. That is a constant that's constantly being evaluated. All of that is on the table. So there is a possibility that sports could be moved from the fall to winter or from fall to spring based on the beliefs that those sports can or cannot be played safely. So the high school league does have a plan pertaining to that, and I just wanted to make everyone aware. They have not shared that plan. They are trying to do any and everything possible to see if sports as currently outlined are able to be played and performed in a safe way. But if there's any indicators that show that this is not possible, then those sports will be moved to a later time in the year when the metrics and the information that is presented deems it a safer time to offer that sport. So that's all I have without getting into great detail, but just kind of giving the board an idea of the thoughts that came out of the league, because I am a part of that decision-making being on the executive committee.
Thank you.
All right. Dr. Rodriguez, are we
Okay.
good with that section, or?
Yes, and the next section, I think, is on the TAN, and that's Ms. Crosby and Franny Heiser.
Good afternoon. I'm going to begin with the discussion, just a brief overview, and then we have Franny Heiser here with us today to discuss some options that the board has on this matter. So as an introduction, for many years, the school district has utilized a tax anticipation note we sometimes refer to as TAN, and this is used to supplement the cash flows of the district in the fall. Without this short-term inflow of cash, the school district's operational fund balance or reserves are not sufficient to cover expenses incurred throughout the whole year. Collection of tax revenues began largely in December and then come in generally in January as well. And this borrowing would occur in September, late September, early October. It would be paid back early January, and my staff monitors the flow, the cash flows very closely so we can pay it back very quickly with as little interest cost as possible. Not only do these cash flows supplement the general fund, but they also help the district fund the special revenue claims. So when we receive special revenue funds, we have to pay those expenses first, spend funds first, request reimbursement, and wait for that reimbursement to return to the district. So we have to have cash flows in the front to be able to receive reimbursement later. And sometimes those funds can be rather large. So Title I, IDEA, and the CARES Act funding are all examples of those funds which we must pay our expenditures in advance and then receive reimbursement at a later date. So with that, the district prepares estimates of where our cash flows will be throughout the year on a month-to-month basis. These have been based on the prior year's expenditures, and they can be adjusted for any changes that occur in the current year, what we may anticipate. After we have performed this projection and these cash flow analysis and have determined that we're comfortable with holding this amount of the TAN virtually the same as the prior fiscal year at $14.3 million. So this is the amount of the need that we have determined for the current fiscal year and the amount that we have proposed in today's resolutions. Our months of greatest need are October and November, as our cash flows, our fund balance becomes to be depleted at that point. And then that way, this tax anticipation note would be drawn down during that time frame. And then as tax revenues come in, we'll pay it immediately back. So we do have some options to discuss with the board today on the pricing of those, and the Franny Heiser is prepared to go over those with you today, and we'll take any questions that you may have on the issue. So Franny, you'd like to?
I'm here.
You're there, good, okay.
Good afternoon. Thank y'all for letting me be with you. And as Ms. Crosby mentioned, that we have two resolutions for your consideration. One resolution would authorize the school district to use the SCAGO TAN program. And the resolution now up on the, that you're seeing now on the screen is for what we would call a standalone tax anticipation note transaction where you would not use SCAGO. I was able to prepare a memo that's dated August the 11th that I believe has been shared with the board members. That memo outlines the due diligence that I undertook in working with Chad Cowan, your current financial advisor, and with the financial advisor for SCAGO. And the numbers, the detail that's attached to my memo, those details are based on projections on the SCAGO side from the SCAGO financial advisor. On the non-SCAGO side, they are based on numbers from Mr. Cowan. Obviously, I think you'll see that the SCAGO would most likely result in a lower interest rate and would also result in a lower cost of issuance. This is really a policy decision for the board.
Ms. Heiser, can I stop you a minute? Because I did not see the document you're referring to. So I don't know if other board members were privy to that or not. The only thing that's in board docs are these two resolutions, and it was clear that they were, so that the TAN would be, obtained two different ways. So the document you're referring to, you're going to have to display.
All right. I'm gonna have to ask somebody how I display that. I don't know, Tanya, where
Robin,
that document ended up.
Robin, those are provided in an email I sent to you on Monday, I believe.
Let me stop sharing and see if I received an email on Monday for that.
You talk about the resolution?
No, did you receive a spreadsheet that showed how they got to those two resolutions?
I thought I saw something that compared the two, but I can't find it now.
Let's see.
No, I can't find mine either.
Yeah, I don't.
Okay, hold on. Let's P card review. Let's see.
Robin, I found if you want to continue sharing, I'll upload those in board docs.
Okay.
Can you put it on the screen though?
Yes.
They're Tuesday, August 11th at 4 p.m.
Tuesday. Okay.
Yes, ma'am.
Tuesday let's go back. 10 documents, 10 memo. I'm sorry. I put the documents and didn't put the memo.
Then I think the attachment to the memo is probably the most important. There we go.
Okay.
Thank you.
All right. Sorry for that.
Good.
I'm sorry. I attached the other documents and didn't do this one.
So the SCAGO TAN program this year, for the first time ever, will actually be a taxable interest rate. The reason that we are going in that direction is that there are a number of school districts who in recent years have not needed to issue a TAN, but they believe they need a TAN this year because of uncertainty regarding state revenue for the most part. So when we issue this note or this debt in a taxable format, we do not require a specific certification from the school districts regarding their TAN. So I do want to note that the SCAGO TAN will be taxable. That projected interest rate came from a large national bank that would be of the nature that would bid on this transaction. So the projected interest cost would be from the end of September, probably all the way till April the 15th, which is when the TAN is repaid in full. And then we have a breakdown of your cost of issuance. Now on the non-SCAGO, which we would call a standalone, the version that you're looking at now would be a tax exempt tax anticipation note that would be sold to a bank. It would not involve getting a credit rating. It would not involve getting a preliminary official statement ready. And the 1% interest rate came from Mr. Cowan. Although that is just a projection, it is very possible that that number could be lower, possible it could be higher. But based on the same time frame, the end of September to April 15, you've got your interest cost and then the cost of issuance. So those are numbers that I would present to y'all, and I felt like I needed to show you options because I think it's in the school district's best interest to have all the available information, and then you, the board, can make your policy decision on how you would like to proceed.
So are there any questions? Ms. Orshak?
Did I hear that there were 2 different motions prepared potentially for action on this matter? Is that correct?
I don't know.
I prepared 2 different resolutions for your
Okay.
consideration.
All right, Madam Chair, I move to postpone any action on this matter until a future board meeting and the board has had adequate time to review the document just presented to us.
Is there any second?
Second.
Okay.
Madam Chair, may I comment since I made the motion?
Yep.
Thank you. The board, a couple meetings back, took action, and I think Ms. Fidrich can speak to it, that we need all documentation within a certain amount of time prior to the presentation. And while it was an honest mistake that we didn't get the document in enough time, we would be going against our prior board action if the board were to go ahead and move forward with a vote today.
Ms. Fidrich?
I'm going to, never mind. Thank you anyway, Dr. Quads.
Mr. Stribinger?
Thank you, Madam Chair. Robin, do you have that email in front of you that you said was from the 11th? Could you just say who was on the distribution list?
Oh, it looks like it's on the screen there, Mr. Stribinger.
Oh, I'm sorry, it's blocked because I have this other thing.
Oh,
okay. Wait a minute.
Because I thought we all got it. I got it, so
Yeah. And I know that I had seen it.
I was just wondering if we all got it, then it's just a matter that we didn't read the email, not that it wasn't put out on board docs.
Yeah, we got it, because I have it.
Yes, sir. Do you have the distribution list in front of you, Earl? Can you?
Yes.
Was it the BOE?
Yeah.
All right, so we all got it.
Yeah.
Okay, Madam Chair, I withdraw my motion if the board received the document in adequate time.
Okay, so we learned this morning, since you already made the motion and it was second, we now have to have a vote. Or withdraw.
Who seconded the vote or the motion?
I did.
Oh, thanks, Kathy.
Yeah, Trish did. But so now we're voting on
Withdrawing it.
the withdrawing. Okay.
So we'll just do the, if we can go, I guess we can just do that's easier. What's easier for you, Robin? Do you want to just call the members' names and say yes or no? They can answer you?
Correct.
Okay, go ahead.
Yes, Robin.
Wait, what is the motion? I'm sorry.
Motion to withdraw the motion?
No.
Motion to withdraw.
Robin, the motion was to,
The first motion was to postpone the resolution on this action.
correct.
Correct, and that was second by Tricia. But now that you withdrew it, we have to have a motion to withdraw your motion.
No. We
Oh,
just have to have a majority say that it's okay to withdraw. That's.
Okay.
Yes.
Okay.
That's what we're voting on. So
Yes.
yes, you want this motion withdrawn, or no, you do not want this motion withdrawn. Robin will read your name and you say yes or no. Everybody clear on that? Okay, Robin, go ahead.
Earl Campbell,
Yes.
John Dowling,
Yes.
Dr. Watts,
Yes.
Joanne Orshak,
Yes, withdraw.
David Strivenger,
Yes.
Kathy Robine,
Yes.
Melvin Campbell,
Yes.
Tricia Fidrich,
Yes.
Rachel Wininski,
Yes.
William Smith, Richard Gere,
Yes.
Geyer, I'm sorry. I'm sorry.
The motion is withdrawn. 10-0-0, one member not present. All right, so to continue discussion, Mr. Scrivener?
Okay, I have a few questions on, to make sure I understand that email. It's like a $70,000 difference. If we go with SCAGO, it's about $70,000 less than if we go with a banknote. Is that correct, Ms. Heiser?
Yes, sir.
That's your
Excuse
take.
me, Mr. Scrivener, can you hear me at this time?
And then my other question is,
Excuse
when
me,
we,
can anyone hear?
Oh, William's trying to talk.
Okay, I'll call on you next, William. Mr. Scrivener has the floor.
Oh, actually, I was just trying to get my mic to work, and I've just been doing this for about the last 30 minutes now.
am I good to-
Because I voted. I was trying to vote on the last motion and a couple motions before that.
Okay.
Mr. Scrivener?
Okay, and then, Franny, when we say taxable and tax exempt, that's taxable to whom?
That is taxable to the holders of the note. The only impact, it has no real impact on the school district. It has an impact on those that purchase the debt.
Yes, ma'am, that's what I wanted to establish. Okay, and my last question is, when we had the referendum passed, we seemed to have enough money in our reserves to basically front the referendum. And I can't remember how much it was. So Tanya, you're saying that we do not have enough in our reserves to front this 14 million?
That's correct. That's correct. It is in the timeframe of October and November that we will need those funds. When we began construction, the amount was $8 million. And we used a portion of those funds, I think maybe 5 or 6 million at that time. So the timing is critical to that as well. We were a little earlier in the school year where our cash position was better through the December, January timeframe. I believe the board motion was, or we began the work or approved the contractors in December timeframe or so. So we had a few months before bonds were issued in March. So we were at a high point in our cash flows when that decision was made.
All right. Yeah, I promised you back then that I would ask that question when we brought the TAN forward, and I didn't want to back off my promise. So thank you.
Mr. Smith?
Actually, I was trying to get on since.
We can hear you, Mr. Smith, clearly.
Can you hear me clearly now?
Yeah, much better.
Okay, I said I've been trying to get my phone unmute for about 30 minutes now. I've been here through all last 3 votes, and I've been voting. And every time I hit *6 to unmute my phone, it seemed like they remute me, so I was not able to unmute. I'm wondering, Madam Chair, could you help me understand why our board members, why can't we unmute and mute ourselves? This is not a committee meeting. No, normally for board meetings, we don't normally have this problem. I was just wondering what was going on today. What was different?
What's different is that we have, since this meeting is not being televised on county channel, there are guests who are actually in the meeting, watching the meeting. And so they have to be muted, and you can't pick and choose who's muted and who's not. So that is why the host or facilitator, Molly and or Robin, have to unmute you. So it's best if you leave yourself on, just don't mute yourself, leave it unmuted.
Or on an identifiable number so that we would
Yes,
know that it was him.
Tell where you are, Miss, they can't tell your number. That's another issue.
Actually, I'm on my district phone. I don't ever call in under any other number. The number should be identified. This is my district issued cell phone I'm calling off of. And also, even when I've been on the Zoom meeting, I had no problem doing it before the beginning of the meeting. It still was saying that the host of the meeting was muting me every time I unmuted myself. It said the host of the meeting was muting you. That's the response I got.
Well, how about Mr. Smith? Why don't we have, would it help you if Dr. Rodriguez had Mark Shohan or somebody call you on your phone to try to, I'm not sure, how we can help you on this end. I've just explained to you the mechanics of this, of the mute and unmute, but I don't know what else to say to you.
Well, I believe I have been pushing unmute, and I've still been muted. And there was times where they've asked me for my vote, and I was not unmuted. And one time, Robin said, "I'm waiting for him to unmute," and I unmuted. And as soon as I unmuted and was trying to talk, it would say that you were muted. The host of the phone, the host would not allow you to unmute. So, and I watched this happen three or four times. 3 times with me voting. Because of the like I said, the first time I was going to abstain, and on the last vote I was going to vote yes. So I mean, I've been trying to unmute, and I've been here, and I've been trying to unmute, and this is an issue because it's not. I have not been allowed to vote when I should have an opportunity to vote.
I'm not on your phone, and I can't answer that. I don't know if Mr. Shohan can answer that, if he's got any insight into what the issue is beyond what we've already said.
Mr. Chowan is not Chohan is not available, not on the call this afternoon, but we can certainly talk to contact someone in technology and see if they can assist.
Do you have anything to add to, do you want to ask a question now on the topic that we're on, Mr. Smith?
Well, actually, yeah, sure. Yeah, I'm going to go. My question was to go back to Mrs. Orszak's motion. Was also to go to this about going over this information. Maybe as a board, maybe we need to. Would there need to be a motion from now on?
But Mr. Smith, the motion, her motion was withdrawn by majority vote, and if you voted, it wouldn't. The vote was 10-0-0. So if you had voted no or abstention, if you had voted yes, no, or abstention, it's withdrawn. So that's off the table now. We're not discussing that now. So how about Mr. Dowling? I can't hear him at all now. Mr. Dowling.
Thank you, Madam Chair. Franny, forgive me if this has been asked and answered already. The non-SCAGO financial advisor and bond counsel fee is $59,300. The SCAGO fee is $29,200 roughly. Okay, could you explain the difference?
Yes, sir. The professional fees on the non-SCAGO are based on the contracts, the procurement, et cetera, that y'all went through to select Hilltop and then to identify me. My firm is your bond counsel firm. On the SCAGO side, the professional fees tend to be less, in some cases substantially less, because from a business standpoint, there is a much larger scale. There will be, let's say, $100 million issued through the SCAGO. So this is an example of like the economies of scale, and that's why the professional fees are different in the two categories.
Oh, okay. I guess I don't understand your answer, because I just want to know why you charge $24,000 on non-SCAGO and $14,000 on the SCAGO.
Yes, sir. The financial advisor at 35 and bond counsel at 24.3 are based upon the proposals that each firm made to the school district. So this is in effect a standalone bond issue, and so the fees would be calculated based on the proposals that were accepted by the school district. Again, on the SCAGO side, the professional fees, as I say, tend to be less because of the economies of scale. So that I don't know how else to exactly answer it. This has traditionally, not only traditionally, it's really always been the case. And this is consistent with the information we presented to y'all last summer. But again, okay, I'm just presenting information for y'all to make a policy decision.
Okay. So do you do more work on the non-SCAGO proposal than you do on the SCAGO?
Yes, sir. There is more work associated with each individual standalone bond issue. For example, we sold debt for y'all yesterday, and it took many hours just yesterday, just tying that process up. So there is more work, and that's the part of the justification. The other part of the justification is that, that was the deal that we made when y'all selected us. Now, I would tell y'all that if you, the board, asked me to reduce my bond counsel fee to $14,000, I probably would do it, even in non-SCAGO, and that's based on our long-term relationship and the fact that I want to continue to have a long-term relationship. However, I can't speak for the financial advisor, and then the difference in the projected interest cost, I have no control over.
Thank you.
Tricia Fidrich.
Thank you, Dr. Glodz. I would just like to hear from our CFO what her thoughts are on these two options.
Yes, ma'am. I have, there is really no preference in one over the other. I would say, obviously, one of my roles is to conserve costs when possible. So obviously the difference in cost would be beneficial to the district as far as the budgetary concerns. Generally under SCAGO, the administration of the program is a little more seamless. They have a standardized process of informing school districts of the timing of certain documents to be prepared and certain payments to be repaid. So there is some, there are reminders and deadlines that occur, whereas if we're doing it ourselves, those would be self-administered. So I would have to, initiate conversations about the need for a TAN, and perhaps, set reminders for myself on certain occasions to submit information to repay bonds. So if I had a preference, I believe that the SCAGO provides more benefit for us than the non-SCAGO option in terms of those two things.
Okay, thank you.
Ms. Orszak?
So, Franny, you are our bond counsel, obviously, but you also serve as SCAGO's bond counsel. Who is their financial advisor currently? SCAGO.
Compass Municipal Advisors.
Municipal advisors, okay. I was told by an attorney that that because you are, SCAGO is a nonprofit, that we would not have access to or that you would not be required at SCAGO to publicly post meeting minutes and that sort of thing. Were you also notified of that information? So if a board member wanted to see how SCAGO conducted business, you are under no obligation at SCAGO to post that information publicly, such as meeting minutes.
Ms. Orszak, SCAGO is not subject to the Freedom of Information Act. So in that respect, you are correct. However, it's the current policy of SCAGO is that any school district participating in the SCAGO programs has access to any information they want. So if a board member in any of the school districts that work through SCAGO has an interest in seeing minutes, agendas, and information related to that school district, that information would be provided to the school district free of charge.
Okay. And is SCAGO classified as a nonprofit?
SCAGO is a nonprofit. That is correct.
That's what I thought. Okay. Thanks, Brandon. And by the way, my apologies again. I missed this document. I don't know how I missed it. I was prepping for 2 finance committees this week. My sincerest apologies, folks. When I didn't see it in board docs, I didn't know it existed. I would like a little more time with it. I'm personally not prepared, having not viewed it in advance. I don't know if any other board members haven't viewed it, but I won't be ready to vote today. I'd like to take a look at this a little bit more closely, if I may.
Mr. Stribinger? Could you please unmute Mr. Stribinger?
Okay, can you hear me?
Yes.
Okay. Yeah, my decision is fairly simple. $70,000 difference is all I needed to know. So I move that the board authorize the issuance of a not exceeding $14,300,000 tax anticipation note, Series 2020, taxable or tax exempt, of the School District of Beaufort County, South Carolina, authorizing the sale of such note to South Carolina Association of Governmental Organizations pursuant to the terms of its TAN program, prescribing the terms and conditions under which the note may be issued, providing for the form of note, providing for the payment thereof, authorizing certain officials of the school district to determine certain matters relating to the note and other matters being related thereto. This will probably be the last time I make a motion that has this many words in it.
I second.
Second.
I think Kathy Robine second. I think she was the one that was first. Okay, do you want to speak any more, Mr. Stribinger?
No, ma'am, I think I've said enough.
Okay, Mr. Dowling.
Thank you, Madam Chair. Franny, who regulates SCAGO?
I don't understand that question. I'm sorry.
I'm assuming that anybody who does financial transactions is regulated by somebody.
SCAGO is a South Carolina nonprofit. SCAGO would have to meet the requirements of the IRS code with respect to it being a 501c3, and it is governed by a board of directors.
Oh, okay. So who audits them?
They have an annual audit that is prepared, and I'm not sure. I think it might be Elliott Davis. I'm not sure who the exact auditor is, but they have an annual audit every year, and they file a required Form 990 with the IRS every year.
So as a bank is regulated by several forms of state and federal statutes. There are no statutes that regulate the transactional business of SCAGO?
Well, as I mentioned, I mean, there's a nonprofit law, there's IRS, and to the extent that SCAGO offers any type of debt in the public marketplace, it's not directly regulated by the SEC, but there are SEC regulations that SCAGO complies with in order to allow underwriters to purchase the certificates of participation that they offer for sale.
That's what I was asking. Thank you.
All right. There being no further questions, we are open for voting, but we need the motion up on the screen first, Robin. Or Molly, I'm not sure who's putting it up.
Robin, give me a second.
Okay,
Here it
there's.
is. Exempt.
David, can you read it? You don't have to read it aloud, but can everybody read it just to be sure we have it the way David said it?
It was what I was typing on the exempt.
It looks like what you said, David. Can you open voting?
Voting is open.
Dowling
Yes,
is no.
I'm sorry, Dowling said no?
Correct.
Got you.
Robin, I think that maybe
see it.
SCAGO is not referenced in that motion. Is that the correct? It's proposed motion number 2.
Okay.
Jeez. So close, do the whole vote again. That's not good. This is.
All
Yeah.
right.
Take
Let me
that out.
All right, let me take that out.
Yeah. We need it right.
Yes, ma'am.
Okay. I know you're trying. That's not a, believe me, I know you're trying.
Where's the vote?
And I took it down.
There you go.
Is that motion correct?
Option 2.
Option
Yes.
2.
Okay, go
All
ahead.
right, I will put it up there. Give me a moment. Nope, it didn't.
It didn't.
I'm sorry, it didn't. Remove it again. Too many screens and I got myself confused. I'm sorry. Molly, I need your assistance for a minute. All right.
Yes, ma'am.
Okay, go. Hold on. Motion. Scoreboard. I got myself locked out.
And board docs, Robin?
Yes, I'm locked out of board docs. Hold on.
Goodness.
Close this motion. Motion. Okay. Let me grab the document. Copy. There's issue taxable. It was made by David. Is that the correct one up?
We don't see anything.
Oh, let's see.
Thumbs up.
That is correct.
Yeah, that looks right.
Thank you.
Do we need to add the words, I move the board authorizes? Do we need to insert, this one just doesn't say anything about moving the board.
All right.
Just a question, I don't know.
I stuck it in there.
Okay.
Authorize. It would be
Authorize, yeah. Would that be an example of strike and insert?
No.
No.
It's not an amendment.
Yeah, that's right. It's just working on the
What the intent was.
the wording, yeah.
Okay. I move the board authorize the issuance.
Yeah. All right, now voting's open.
Dowling, no.
Okay.
Check now.
Mr. Smith, are you on your computer or phone, or can you hear us?
Oh, no, they'll mute me. Yeah, I will abstain.
Okay,
Thank you.
you're welcome.
Mr. Earl Campbell,
Yes.
voting's closed.
Did you get Mr. William Smith abstention?
Yes, I did.
Okay, good. All right. The motion carries 7-3-1, and the noes are Dowling, Orishak, Mel Campbell, and the abstention is Mr. Smith. All right, now, does that conclude your TAN report or presentation? Yes.
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 Yes,
thank
ma'am.
you.
Thank you.
Thank you very much.
Ms. Heiser and Ms. Crosby. The next item on the agenda is fiscal autonomy. And I think Tanya was going to give a little background.
Yes, ma'am. At a recent joint board meeting between Beaufort County Council and Beaufort County Board of Education members, there were a few items discussed, one of which was fiscal autonomy. I am aware that over the years, this issue has been taken up several times through the course of many years, as recently as 2011-12 school year. I know that districts are very diverse across the district on the matter of fiscal autonomy, about a third, with those with full, those with limited, and those with no autonomy. As far, and as well as that, there have been notable shifts over a period of many years from away from having no authority to either having full or limited authority. So a number of other school districts have addressed this very same issue in the past. One thing I'd like to know, it is extremely important to have, for the board, to have a conversation and an analysis of the benefits of fiscal autonomy, as well as concerns that taxpayers and board members themselves may have on the topic. So a study of that, I think, is very important. And also to have a discussion of the process is very important. Understanding for yourselves and for my benefit as well, what the exact process is and what elected bodies or elected officials are involved in the process if the board chooses to move forward. So this time I'm going to pass that back to the discussion back to the board to discuss the topic, and if you decide what direction you are interested in going in, I'll be happy to assist in any way. And if you decide to pursue the matter, I think guidance from someone who has knowledge and extensive experience on this matter is really important. So with that in mind, we'll turn it back to the board at this time. We'll be happy
Okay,
to take
so
your questions.
I have a request, Tanya. I remember when we had the meeting with the county council, the 3 board members and the 3 county council members, you had the document from the South Carolina School Board Association, which showed the breakdown of about what the different districts, what type of fiscal, I should say, responsibility they had. As you just mentioned, the 1/3,
Yes.
1/3, 1/3. Can you display that on your screen?
I sent it to Robin. I did not ask her to share it with the board last night, but I did share it with her in case this came up. So,
that on the screen, please.
Robin, if you can find probably my last email to you may have had a link to that.
And then I'm going to go to Mr. Geyer, since you were at the meeting with County Council, I believe it was in May, since you are also the liaison to the County Council, I'll let you lead the discussion. Could you please unmute, Mr. Geyer? Thank you.
Thank you, Madam Chair. At that meeting, we talked about it, about the possibility of having fiscal authority. And the reason that I believe we need fiscal authority is we are elected officials. The state statute says millage can be set only by elected officials. And it's different in some districts where the county or the county council will appoint the school board. And in that case, obviously the county council should be the fiscal authority. In the very complex, large districts, most of them have fiscal authority. One of the things that I realized when we went and talked to the county council year before last about our budget is the lack of knowledge that the county council has about the complexity of our operation. And that's not surprising. They have their own issues to deal with. But having them approve our budget or what we're going to ask for the citizens to pay in this full tax, it's kind of like having them have to come to us to justify their taxes that they're asking for the citizens. I was told by a county councilman that no, we on the school board should only be interested in our children's education. And we at the county council, we have the big picture and we are best to give you guidance and to supervise your budget and how property taxes.
Here are some results from the web.
That's not me. That's just not right. And my response to that is not one student voted for me on the school board. Parents voted for me, grandparents, family members, and just citizens like me who are retired here voted for them. Now, I will tell you, going door to door, I would say only about 20–25% of the people that I knocked on the door and talked to were actually parents of children in this school. So I was asked a lot about how we spent our money. And was I a fiscal conservative, for example, was asked. And yes, I am. I'm a taxpayer too. And I want to make sure that we provide the best education that we can, and that we do it in a very good and very prudent fiscal manner. That we don't waste money, that we ask what we need. Now, the problem also has been that the county council, to set the millage, especially in the last 3 periods when we had the reissuance of, challenging for the word now, not the redistricting, but the
Assessment.
assessment, right. The last 3 times they did that, the county council, they underfunded us. And they underfunded us last time they did it for a tune of $9 million. They underfunded us the second time for a tune of $5.2 million. And the third time for $5 million. So $19 million. And if you looked at, if we had that $19 million back, we wouldn't have to ask for a TAN. We would have enough in our fund balance that we wouldn't have to spend $70,000 on interest rates, because we could have the funds to do our period of low revenue stream, and we could pay the bills. So they don't have a good track record supporting this school district with funds by setting the millage rate too low. And we should be responsible. We should say, this is what it's going to take to fund this school district. And if we screw it up, it's nobody's fault but ourselves. In each case, when I look back at the history of what the school district asked for on those 3 times, 3 issuance, if we would have gotten what we asked for, we wouldn't have been in the problem that we had. So this is time to take back, or not take back, take authority for our own operational funds. And I don't know the process of doing that, whether we have to have a referendum. I've been told that maybe we have a referendum, or maybe we have to go to the state and ask for legislation from our representatives. But I think we could make a very good case of why we should have fiscal autonomy for the Beaufort County School District. Thank you, Madam Chair.
Thank you. Ms. Orszak?
Thank you. I'm going to cut right to the chase. It's my understanding the process is it has to be put to voters on a ballot. Does anybody know if we could possibly put this to voters in the general election? I mean, it's going to have a huge voter turnout. It would be an optimal time to take the pulse of where our voters feel, what their position is on this. Do they think that the school district, the school board should have fiscal autonomy or no? It's my understanding that the last time it was put to voters, and I'm not certain that it's still a requirement, but the last time it was put to voters, it didn't fare well. But you know, who knows? Maybe now it would do quite well. So I need some answers on that. Are we too late to put it on a ballot for November? And is that even still the process? Do we need to put it to voters? I'd put it to voters tomorrow if given a choice. If they have to decide, I think sooner rather than later, put this issue in front of them. Can anybody answer that question?
Ms. Cartledge, do you know the legal process?
Board members, this is not an area that I have ever worked in before. I did look up the districts that had fiscal authority, and there's the variety. Last time Ms. Crosby said 1/3, 1/3, and 1/3. It just seems to me we need to get somebody to help us, but we need to, you as the board need to speak with county council and see what kind of support you have from them before you move forward. I'm not sure if you have to have a special legislation that the legislative delegation would introduce legislative, or as Ms. Orszak, the voters, she mentioned that it was actually on the ballot before. So we need to look into what the procedure is, and I don't know who is, who's a specialist in this area, but that you all need to consider, because to me, it seems that you should be in control of setting your budget and setting your millage rate. It's like Mr. Geyer said, you have lost a lot, $19 million short that you could have had in your fund balance for going for education for our students. So.
May I have a follow-up, Madam Chair?
Yeah.
May I have a follow-up, Madam Chair?
Yes, I answered yes. Yes, go ahead.
I apologize, I didn't hear you. Is it possible to ask our lobbyists? I mean, time is of the essence. We could, if we're not too late, potentially get this in front of voters in one of the biggest elections, one of the biggest turnouts we're going to see over the next few years. We've got 4 board seats that are going to be on that ballot. This would be a perfect complement to that. I don't know if the board would even want to put it on a ballot. I know I certainly would like to understand how voters feel if their vote is required on this matter. But can we ask our lobbyists if they know about this, or really just contact any member of our legislative delegation directly on this?
Mr. Dowling?
Thank you, Madam Chair. Just out of curiosity, how did this topic come up? If I recall correctly, the request to have a meeting with the council was about other matters, and the board has never taken a position on fiscal autonomy. So how did the situation come up? And is the council under the impression that the board looks upon it favorably?
Well, I'll answer that. The council, that was one of the topics we discussed. The 3 representatives from the Board of Education and the 3 representatives from the council that took place in May, and I don't have the agenda in front of me. Fiscal autonomy was one of the topics, and they were the ones that set the agenda. And they wanted to know, what does the board think of this? So that's why it's why it's on this agenda, sir.
All right, good answer. What is being asked of the board today?
Well, I think we need to know the process of you know, how to approach this. And it seems obviously from our discussion, we don't know the process, but let's see, maybe somebody else who's going to speak right now will has more knowledge about this.
All right, thank
Dr. Wisniewski?
Thank you, Madam Chair. I was trying to pull up the deadline. I know it's in August, but I can't find the actual date. So I know time is of the essence if we did want to be on the November 2020 ballot. It's in August.
Mr. Stribinger?
Thank you, Madam Chair. I don't think we have any clue on what the process is. I thought at that council meeting they outlined a somewhat lengthy process that would span years. But I think what we need to do to answer Mr. Dowling's question, we have to have somebody outline this process so we know what we're talking about. And I'm not sure whether you're going to appoint somebody to do that, or an ad hoc committee, or I think someone suggested our lobbyist. I don't know who would be the best, but there's no sense in us continuing to talk about it when we don't know what we're talking about. We need to get somebody who understands the process.
Okay, thank you. Mr. Campbell, Earl Campbell?
Yes, we have two choice. And many of the districts that have physical autonomy have went that way. One, have a vote, put it on the ballot, or submit a request to the delegation. So those are the 2 choices we have.
Dr. Wisniewski? Okay.
Sorry, I put my hand down.
You did or didn't?
No, I just put it down. It was still up on it.
Mr. Dowling? Mr. Dowling?
Madam Chair, I'd like to make a motion. I move that the board direct the chair to set in motion a process which will result in a full report to the board as to what the exact process for having this issue examined is.
Second.
Was that Mr. Strivenger?
Yes, ma'am.
Yes.
Mr. Dowling, please say, Mr. Dowling, please say that. I move that the board direct the chair to set in motion a process
That will result in the delivery to the board of a full report on exactly what the process in achieving the objective is for achieving fiscal autonomy.
Fiscal, yeah, what's that? I don't know.
Okay, Ms. Robine?
Yes, I was just going to say, I agree. We need some information about what the process is. I'm, for one, am interested in finding out what has to be done to do this. I, believe what Colonel Geyer said. We've not been fortunate. Not the millage rates that have been set by others, by the county, haven't benefited us, haven't met our needs. So I think we need to explore how we can assume fiscal autonomy, but we need to know a process.
Dorshak?
I think it does need to be explored. I agree with Kathy. It hasn't been explored in many years. It didn't work out well the first time around, but as I said, perhaps a lot of things have changed, and we may have some success this time. It really, if it is required, if we do find out that it is required to be placed on a ballot, it really would be ideal to have it in this election, because we would get a very quick turnaround, as well as it being accompanied with several board seats. Whereas, we won't have that opportunity for another couple of years. So is it possible, John, did you insert, I thought I heard you insert something about when we would have a report on the process. Did you, yes or no? In your motion?
No.
No, okay. I would like to amend the motion to include after the words fiscal autonomy by the board's next regularly scheduled board meeting.
Did you hear that, Robin?
Robin, did you get that? I can repeat it.
Yes, I'm typing.
Take your time.
Has the motion been seconded?
No.
I thought you,
By you.
by
I'll
you,
second
John.
it. Yeah.
Yeah.
Yeah, okay.
So can we please unmute Franny Heiser? She would like to, I think she has a comment. Go ahead, Franny.
Thank you. I stayed on to listen to this because I know that the school district has looked at fiscal autonomy in years past. I am not aware of any requirement that the issue be put to a vote, like a referendum. You could have a advisory referendum, which might give you some momentum in going through the political process, but an official referendum I don't think is required. Also, state law says that any question that's going to be on a general election ballot has to be delivered to your local election commission by noon on August the 15th, which is actually tomorrow. So that day goes to the 17th.
That's true.
So I don't think you would be able to get a question on the ballot in November. However, again, I don't know that a question in a referendum is needed. And the process that has been undertaken in the past has been for the school board to talk to your legislative delegation and ask that they introduce special legislation that would take the ability to approve budgets and levy millage from your county council to the school board. And just in the political process, I think in the past there may have been some resistance to that on the part of your county council. So if county council members thought that it was time to send that responsibility to the school board, to the Board of Education, where I do personally believe it belongs, then you would probably have, again, momentum in working with your legislative delegation. And I've never participated in any of the efforts of Beaufort School District to get fiscal autonomy. I've just observed them from a distance or from as a spectator. But there are folks I think that have helped y'all in the past, and certainly you could either have your inside counsel or engage an attorney to help you with that process. And I also know that y'all do have a lobbyist. I think the lobbyist is shared with the county. So again, if county council and the school board were in agreement with this, it might be appropriate to have your lobbyist help work on this issue.
Thank you for your comment. Mr. Strippinger?
Thank you, Madam Chair. Our next regularly scheduled board meeting is Tuesday, is it not?
Yes.
So this would have to all be completed on Monday, and if there's a write-up, it would not be out there in time for us to review it, would it?
Exactly.
So I'm not sure how you could pull this off.
I don't think I could. I think it would be impossible.
So that's why, Madam Chair, the clarification on the motion, it says set in motion a process, or is the motion to have the report by Tuesday?
Good point.
The amendment covers that. The amendment says a full report of what the process is by the next regularly scheduled board meeting. So that's the motion before us now, not the original motion.
I thought the amendment was just by the next regularly scheduled board meeting.
That's correct. That's correct. But
okay, so I'm going to say, in terms of the amendment, I don't think that's physically, humanly possible to do that by the next regularly scheduled board meeting. So I'll be voting no. I can't do it. I can't execute it. You've asked me to do it by August 18th, and we have a weekend. You've given 1.5 business days at best to make all the calls and whatever research I need to do, plus develop a report. I can't possibly do that. Mr. Earl Campbell?
Yeah, I agree with you on that. I would suggest that we go through our delegation.
Yeah, and I think the lobbyist through the lobbyist also is a good idea.
Right, the lobbyist and the delegation.
Ms. Orshak?
Okay, just a couple things. Mr. Campbell, you were on the board when the county voters voted on that autonomy. They did vote. I saw results from that. Is that not correct?
Yeah, we were turned down. We was not successful.
Yes.
Because a
So
lot
I
of
just
folks
wanted to
said
bring
that-
that forward to Ms. Heiser, that it did happen, perhaps,
Right.
I don't know if it could have happened incorrectly or not, but it did take place.
Well, right
Um,
now,
yeah.
right now, we
A
would have to wait until
referendum
next
can
year.
be advisory, so, I mean, there's nothing illegal about putting questions to your voters, and that may well have been what happened. It was not an official, it was just an advisory referendum.
Right.
And I think because they are the stakeholders, it might be advisable again. There might be something already in writing somewhere, a law, guidelines, what have you, that a simple phone call to, our legislative delegation or our lobbyists just to produce for us. Is there anything in writing? That's all. The board just needs information. As Franny stated, it would have to be on a formal referendum by a certain date, and clearly that's new information, and we did not have that when this motion was put on the floor here. But I see no reason why we can't reach out to someone, say Monday, and ask them, are there any formal guidelines? Is it written somewhere? Can we just have it for board reference? I didn't request to put it on a board agenda. I just said by the next regularly scheduled meeting. And you may come up empty-handed, Madam Chair. They may say, nope, we've got no guidelines. We've got nothing in writing anywhere. In which case, then it'll probably take a little more time. But I'm going to keep the motion as is. I'm not going to withdraw the amendment. I see no harm in asking early next week. You may not get a response, but certainly we can reach out early next week. Just to find out. We've been wondering about this a long time. We haven't taken any action on it. We don't know the process still. Let's just get going on it. And perhaps Ms. Cushingberry can assist if there's no way to, work it into the schedule Monday or Tuesday.
Ms. Robine?
I think that we're, depending upon what we're asking, is how I would vote. If I interpret this as saying we're asking the chair to talk about the process and give a report on that, the process being I am going to make an ad hoc committee, or I'm going to reach out to this person or that person. If that's what the process is, then I could support it. But if we're asking her to come back with the process of we have to do A, B, C, D, I don't think she has enough time. I don't think there's enough time. So I would need some clarity on that to determine what exactly are we asking.
Kathy, are you asking me?
I guess we all have to agree though, right? Because we all have to know what we're voting on. Yes.
Absolutely. Well, John Dowling put the core motion on the floor. So I think Mr. Dowling should speak to the word process and what that might entail. For me, if I may just finish my thought, I think we ought to be able to get something in writing somewhere from somebody by Monday or Tuesday. It doesn't have to be on the next agenda, but I think we ought to get something in hand. It should be a relatively quick piece of information to abstract from the appropriate source, but I'll hand it over to Mr. Dowling's explanation for what process might refer to.
Thank you. All the motion asks the chair to do is to authorize someone to set in motion a process, authorize someone to call somebody, like, for example, our lobbyist, and get the 10 basic steps that have to be accomplished, or the 5 basic steps. And then we know what we're facing. It should take the chair 30, 40 seconds to ask somebody to do it. And then somebody will have the rest of the day today and all day Monday and part of the day Tuesday to get those basic steps down on paper, hand them to the chair, and the chair can put it in her report for Tuesday night.
Mr. Earl Campbell?
I don't see why you're trying to make it so hard. Like I said, talk to the delegation and the lobbyists, and that's it. Because there's no way we're gonna get this on the ballot by Monday. It's impossible.
Rachel has her hand up.
Okay, thank you. Dr. Wisniewski.
Thank you, Madam Chair. I move that we strike next regularly from the motion and replace it with September 2020.
I second that.
Well, okay.
So that gives more time for the chair to accomplish the task and hopefully bring forward something. We know that we're not going to be able to get on the ballot by tomorrow if that is the route that needs to be taken. So let's give a little bit more time and let her come forward with something that's comprehensive and has, allowed her the time to vet all the options that are available to us.
Mr. Dowling.
Thank you, Madam Chair. Yeah, I'd just like to offer this, and not in a snarky way. We pay our lobbyists $40,000 a year. I don't think it'll be a big favor to ask her to compile what those steps are and get them back to us as fast as reasonably possible. Franny Heiser seems very confident that there does not have to get on the ballot. So I don't think that's an issue. So I think that I would support September if we can get a date certain in there. September has 30 days.
Well, I apologize. It should have still said the September 2020 board meeting, the language that reflected that it was the regularly scheduled board meeting. But that
Which regularly scheduled board meeting?
We can say the first.
Okay.
I believe that's September 1.
Didn't have it.
Okay, so is there any objection to, we switched out, we really, we had one amendment with the date of, like we said, a day and a half of a business day and a half away, and now we've switched it to about 2 weeks away. If anybody objects to that, we need to vote on the first one. Okay, so we don't have to vote on the first one then. So the other thing that I find troublesome with this or concerning is a full report. Can we remove the word full? But, I don't know what that, I understand what I'm supposed to do, but a full report, that sounds kind of,
yeah,
some are onerous.
That makes sense. It's superfluous.
Okay, thank you. And is there any objection to removing the word full? All right, so Robin, could you remove that too, please? Strike full.
To be clear, it says by the next regularly scheduled board meeting. It's not technically our next, so next.
So just say by.
I had moved to strike the next part.
So just put by
the regularly scheduled board meeting.
Board meeting, September 1. You need the next removed also. That's before regularly. Yeah.
Thank you.
All right, so I'm going to read it again. I move the board direct the chair to set in motion a process that will result in the delivery to the board of a report of exactly what the process is for fiscal autonomy by the regularly scheduled board meeting, September 1, 2020. Mr. Smith.
He's muted.
Could you unmute him, please? Mr. Smith, you're unmuted.
Oh, yes, ma'am, I'm unmuted. Actually, you answered my question. It was about what does the full report mean, but you actually asked my question.
Okay, good. Mr. Dowling, your hand's up still or not gone down or?
I apologize. It's going down. It's down.
Okay, so I think we're ready to vote.
Yes.
Voting is open.
Dowling votes yes.
Orshak, yes.
Mr. Earl Campbell,
Oh, I'm sorry, yes.
Mr. William Smith,
Yes.
voting's closed.
Motion carries unanimously, 11-0-0. So we are now down to the break, but we're about an hour behind, but let's take I think a 15-minute break would be good. And we'll do the 10-minute break. Back at 3:45. Okay, 3:45, we'll return.
Oh. We get so far behind. This is my thing.
Okay, we're back in session and it's 3:45, and like I said, we're unfortunately about an hour behind. So we're now down to the agenda item, update on ACE, Dr. Rodriguez. He probably needs to be unmuted. Could you please unmute Dr. Rodriguez?
Okay, can you hear me?
Yes, thank you.
Okay, all right, thank you. Just a brief update on ACE. At the next ACE board meeting, the director, Dr. Lavecchio, is going to be bringing forward a request for an ESOL position. That was something that the ACE board had talked about at that time, at the last meeting, excuse me. And so he is going to bring forward a request for that additional position so that they can make sure they are able to meet the needs of their ESOL students there. So that's essentially the update that I have for ACE. And any questions?
Mr. Mel Campbell? he needs to be unmuted. Yeah, thank you.
Okay, got me. Yeah, how does ACE relate to our virtual education?
Yep. So we have students at ACE that are obviously are Buford students, and they have a virtual component for their classes as well. And then they do have, because some of the class sessions that they have require some hands-on for certifications. So Dr. Lavecchio is putting together a plan that he's going to share with the ACE board at the next meeting.
Okay, so obviously they're having both sides because Jasper is
virtual.
Not virtual,
Also.
Is that correct?
Jasper is virtual also, yes.
Oh, they're virtual also. Okay, so this is more hybrid because it's ACE.
Right. I think it's because of the some of the specific requirements for some of those courses when they become necessary to do it. If they're still in that virtual mode, if we're all still in the virtual mode, then they would have to provide some of that and follow real tight restrictions. But some of the courses require that hands-on component in that CTE piece at ACE.
So I want to throw a curveball at you, but how does that relate to the courses that require those pieces in the other schools?
Dr. Stratos, Mr. Campbell's question is on the workaround CTE courses. If you can unmute Dr. Stratos, thank you.
We met with Dr. Lavecchio on Wednesday. He was at the district with our principals meeting. He did make a request to utilize the same licensing that we use here in Beaufort County for the virtual context for the academic courses. So we're making arrangements to provide that for our students because he does house some content courses within ACE itself. We're working that out at this time so we can have our students within the districts and our district to maintain consistency. And I believe they're working out from the Jasper side, so that teacher is working with one platform, Mr. Campbell. With regard to the CTE component on virtual, they're going to be following a similar model to ourselves. If and whenever possible, we're going forward with as much practicum work as that is needed. The hands-on component required, the hands-on part required for industry certification will have to happen as we go back into the building, because there is requirement for licensing for the amount of hands-on that our students receive, from welding to cosmetology and electrical. So there are some components that we are managing, and we are sharing software with Mike as well.
Okay, so let me hear you correctly. You're saying that our programs that require hands-on will eventually have time, hopefully, to get the hands-on into the classroom, if we go back to the classroom.
That is our ultimate goal, Mr. Campbell, and I apologize. That is our ultimate goal. We can't control the COVID. That's a licensing component that we do not have control on from our side.
But my question is, what if we never go back?
Dr. Stratos is on mute, yeah.
Yeah.
What if we
What
never
the state,
go back?
what we were able to do over the summer was organize small group practice for our students with the agreement of the parent and the instructor. So we put in place some part-time dollars to help out for that to happen, Mr. Campbell, as well as for driver's ed for our students. So we had to address it uniquely and be creative to address the needs of the kids in order to get them ready, either for the licensing for driving or for any industry certification exam they were sitting for.
So
we did
your
make
plan-
accommodations.
Your plan is contingent on face-to-face, but if not, we got a backup plan. That's what you're saying. right?
Absolutely, sir, we have to. Mrs. Gilbert, Karen, we're in constant communication. She's even put a request to utilize some of the K-12 courses at the high school level for Kate. We were speaking last night about that, and we're reviewing some numbers. We do have a backup plan, sir. Yes, we have to. We have to get the kids ready because the vocational component and readiness is part of independence for financial security for kids.
I just don't want them to spend the whole year without being able to get their certification.
Yeah, the state has been strict on the guidelines on the licensing component.
Right, but I'm sure they haven't given you any resources to get it done. Other than
I won't say, I'm not saying nothing, sir, regarding.
I'm saying that,
Yes,
yes.
sir. Yes, sir.
Thank you.
Ms. Fidrich?
Thank you, Dr. Quads. I just wanted to let the board know that we do have an ACE meeting on the 20th at 1:30. So I'm anticipating that some of these questions, such as yours, Mel, will be answered. I also understand, if I'm correct, the Jasper County students are starting on Monday virtually. So Dr. Lavecchio and Adrian, the assistant executive director, they've worked very hard at trying to mesh the two different calendars, and they've become quite adept at being able to do so. So I just wanted the board to know that at our first meeting in September, we will have a much more detailed report too of how, what's going on at ACE.
Ms. Orshak?
So, Dr. Rodriguez, these small group gatherings, or Dr. Stratos, were they conducted at ACE's facilities or our facilities for our own students, not Jasper students, but for our Beaufort County students participating in those courses?
Mrs. Orshak, I can't give you the specifics for the locations, but I will share with you that the opportunity existed for our kids. I will speak directly regarding welding, because that was something that I did have my hands in the approval process of that. And that was at Battery Creek. The instructor at the time who was there, a gentleman, he was given an option to do some work with our kids.
And so small group is 5, what's a small group?
I don't know. I don't have the attendance record for that, ma'am.
I'm trying to get a handle on, since the state doesn't seem to be loosening up, if you will, on requirements for certification. I'm just trying to get a handle on how many kids were able to get in the queue and actually certified through in-person instruction and the completion of their checklist, if you will, of hands-on practices.
So the licensing component for industry certification is outside the umbrella of the Department of Education. And those two departments, my understanding, did have a little head clash because they recognized the COVID scenario. So I don't have the exact numbers, but I will get that information from Mrs. Gilbert from Karen, ma'am.
Excellent. So the students that did their hands-on practicing at Battery Creek, were they ACE students or were they just our students taking similar courses within our district?
The situation I was involved in was with regard to students at Battery Creek.
Okay, Battery Creek students, not ACE students.
No.
Okay, thank you, Dr. Stratos.
Yes, ma'am.
Mr. Earl Campbell?
I was just going to say that I have a copy of the returning plan. So what I would do, I would send it to board members. Okay.
Thank you.
Have all the information you're talking about.
Why don't you send it to Robin and she,
Okay.
that'll make it easy.
That's what I'll do.
Thank you. Thank you very much. Ms. Fidrich, your hand's still up.
Oh, my apologies, Dr. Quads.
No problem. All right. There being no questions, further questions, I should say. It looks like we're on to the last agenda item before recessing until tomorrow. This item is discussion of board members' access to resolved personnel issues. Dr. Rodriguez and Dr. Walton, Alice Walton.
Go ahead, Ms. Walton.
I guess I need to ask a clarifying question. When you say resolve personnel issues, tell me exactly what you are looking for.
Well, that was Mr. Dowling's request, so I'll let him answer.
Thank you, Madam Chair. Where I was coming from on that is that board members are basically in the same category as the newspaper when we make inquiries about what's going on with a personnel issue. We don't discuss personnel issues. I maintain, it's just my opinion, but my opinion is that we have ample evidence that we are the employers. We've had, in practice, we've been the employers. We had an attorney come in on the grievance issues and tell us very clearly that we were the employers. And the Attorney General was good enough to pitch in an opinion and say, of course the board is the employers. If we're the employers, then we are in all cases the client. I don't care who in the district hires the attorney. As the employers, the head group, we are privy to information, maybe not the names, but I think that the term confidential information is used too broadly, and it puts us at a disadvantage in trying to present the district in the best light. So here's an example. Last week, when Wendy was going through the Title IX ARs with the Operations Committee, Mr. Smith asked, could we get reports when they start tracking these grievance things? And so the response was, oh, that's confidential. Okay, I'm maintaining that we need a much more precise and accommodating definition of confidential before, in order to get all the aspects of our job done. And I'm basing my claim on the fact that we are indeed, from multiple sources, considered the employers of the school district.
My response to that, Mr. Dowling, is I can tell you why we have maintained this practice. Of course, it is certainly up to the board to request or do what they want to do. But we have done this because it's not like we're trying to hide anything per employee. It is because you will sit as a judge and a juror if an employee A finds that they want to either grieve or this action ends up in a termination or non-renewal, then that has to come to you as the board to make the final decision or overrule the administration. And if we give you all of the details leading up to that action, then you can be deemed as prejudiced against that employee once you have to make the final decision. But I'm not a legal mind, so I would have to defer to Ms. Cotledge in that instance. But I can tell you why we have done it up to this point.
I understand that perfectly. That's not my point. My point is we can't even find out if a teacher, without being named, has been reprimanded or terminated or disciplined in any way when something happens. And I think that's excessive. That has nothing to do with our adjudication of the issue someday in a potential appeal. So I would move that the board ask the policy committee to develop a policy on the definition of confidential information and what types of confidential information will be shared with the board and not shared with the board.
State that one more time, please. Mr. Dowling, state that one more time, please.
Oh, okay. I move that the board ask the policy committee to develop a policy giving the definition of confidential information in the context of what the board will receive and not receive from the administration around us, particularly once a disposition of the case has been made.
I'll second for discussion. I have a question.
Do you have anything more to say, Mr. Dowling?
Nope, nope.
Okay. Ms. Orszag?
John, your motion, I haven't seen it in writing yet, but I don't think it references personnel matters. And it sounded like from the agenda item that your request was very specific to personnel issues.
Oh, I'm sorry. I apologize. I did leave that out. Confidential information on personnel matters. Let's see, the board asked the policy committee to develop policy giving the definition of confidential information regarding personnel matters and just take the word about out and insert and.
And I think you need the word regarding after confidential information in that first line, regarding.
Yeah,
Okay.
regarding is there, yep. Now, I might add that I'm not talking specifically about this latest issue with a teacher. I'm talking in general terms.
Ms. Orszag?
Let's
sorry, Ms. Fidrich's hand is up and you spoke. I'm sorry. Let me go to her first.
Yes, of course.
John, could you explain what you mean when you say once the deposition has been made? What?
Disposition.
I don't think board members should be involved in the disposition of an issue, of a case. In other words, recommending to the superintendent that a person be reprimanded or fired or any kind of action. Once the action has been taken, though, I think we should be briefed as completely as possible on the situation so that we understand. We have to evaluate the superintendent on the type of personnel decisions he makes. And how are we going to do that if we're not? Yes, Mary, we do. How are we going to do that if we don't know the type of decisions that he's made?
Okay, thank you. I just, the motion prior said deposition, and I wasn't certain if that's what you meant. So I understand. It's been changed.
Yeah.
It's been changed. Thank you.
Ms. Fidrich? Sorry.
I'm taking my hand down.
Yeah, Mel Campbell, sorry.
Yeah, John, are you concerned with whether the policy states whether it could be this, disseminated or should be?
I don't
You understand
fully
what I'm
know.
saying? I mean,
No.
I don't understand. Does the administration have the right to withhold if they want to, or will the policy state that they have to dismiss every time they have information?
Well, I think
on an
that
employee.
that would be discussed at the policy committee level. I think that would be discussed at the policy committee level when they enter. If this motion passes, then the policy committee will take that on as a facet of the discussion.
Okay. So you just want them to develop discussion then?
I'm asking them to develop a policy around the dissemination of confidential information with a description of what confidential information is and isn't.
Okay.
So I won't be supporting this motion, and the reason is that I won't be supporting this motion is confidential information. Well, we can have a policy of how this information should be disseminated among the board, or what should be released or what shouldn't be released or whatever. But that in itself doesn't mean that that will be adhered to by board members that have this confidential information. This to me seems like, ooh, you're asking for trouble, because I think you're going to be potentially employees, I don't think are going to want to have their confidential information released to board members, perhaps when it's not really necessary. And I agree with Ms. Walton, when employee is, I don't know, reprimanded or disciplined or whatever it is, ultimately an appeal of whatever the end process might be. For example, the superintendent may recommend termination to an employee, and ultimately that decision is appealed by the employee. In which case, once that would be a situation where the board would function as the the jury, as just as Mrs. McFadden went over this morning. So I don't know. I also think this could be a way to get at any employee who's filed a grievance. I think that's, I don't know. I just don't like it. It just doesn't sit well.
Okay, Madam Chair, if I may, I hope there's no insinuation in there.
Out of order. You do not have the floor. Next.
Would you give me the floor, please?
No, you're not. You have to raise your hand like everybody else.
Oh, I'm sorry.
Miss Wendy Cartledge is next.
Yes, I just wanted to clarify. I know that Ms. Walton gives the board a very thorough report in her ratification report every month, and it discusses what has happened with respect to resignations or hires or whatever. So what I'm trying to understand is, if I could please seek clarity, is with respect to personnel actions or personnel issues. I mean, there are very many different kinds of things that take place. For example, sometimes we have employees that need to go into counseling. Sometimes we have employees that need to seek rehabilitation because they have a problem that needs to be addressed. So we deal with some health issues that are personnel matters, but they're of a confidential nature. Sometimes individuals are given a sanction where it's a reprimand or it's a counseling session. So I'm trying to figure out what the board would like to, what kind of information that you all would like to receive with regard to personnel matters. So I'm trying to figure out the type of action and what information you seek so that we can be responsive to your request.
All right, Mr. Strivinger.
Thank you, Madam Chair. I would ask the board to trust the policy committee to deal with all of these questions. Because they are legitimate questions, policy committee will have to hash through them. Such as, the board, not board members, would have access. So there's a lot of issues the policy committee can work through. I don't think we need to discuss them here right now. I think the policy committee has a clear, at least this member of the policy committee has a clear understanding of what you're asking. So I would suggest that you let us do what you're asking, and then we can have these discussions.
Mr. William Smith, he needs to be unmuted.
Thank you. My thing is that I do support Mr. Dowling because of the fact of actually, let me ask this question to Dr. Rodriguez. In the current policy that we have right now with grievances, what is the highest level to access grievances right now?
Ms. Walton?
Mr. Smith, are you talking about the appellant?
Yes, ma'am. What's the highest level that a person can grieve?
Superintendent.
The superintendent, right? So in other words, they can't bring their grievance straight to the board.
No, our regulations are not set up that way.
Right. So therefore, I think that saying that the board members don't even see the grievance will be pretty fair, because basically, if you grieve how I perceived it, is that the grievance if the far as grievances go is to the superintendent and HR, and after that, then if you still want to appeal it, then you have to go out and get an attorney. So therefore, I don't think that the board directly deals with grievances outside of what what lawsuits that may occur to the board. So I don't think that there is much of the board hearing grievances, because the last time we had a discussion, if my memory serves me correctly, if my process of understanding was correct, the highest level of hearing grievances was pretty much stops at HR. So not only was that concern that the grievances stop at HR, it's almost as though that the board basically does not really have anything to do with the grievance, unless there was an attorney brought in and they brought it before and they attempted to bring it before the board. So and with saying that, I really don't believe that the board would have precedence against anyone with any of these decisions, because of the fact that also you may have as a board member, you may have someone coming out to who may be a staff member coming to you as a board member saying that they're not getting any justice, or they feel that people are looking down on them and that their situation is not getting looked at. And if you can't talk to it, or you can't understand what's going on to see whether the person is telling you one thing but something else is going on, then how can you entertain it, or how can you do your job as a board member? So there's a lot of gray area here of what Mr. Dowling is talking about when it comes to personnel matters. And I think that sometimes that personnel matter is thrown around anytime that they don't want to discuss things with board members. And that could be my perception of when they think that it is something that they want the senior staff to deal with, and not the board member. But to close it, it's just that I do support this motion, and there's a lot of validity in what Mr. Dowling is saying. And once again, also, the last time we had, my recollection also concerned me last time that we had possibly a case coming forth this board that we were talking about. This same board, I believe, was talking about hiring an attorney to hear the case and an attorney to advise the board on what they thought about it. So the board wasn't even going to hear the case. So I'm trying to figure out how is it in violation, or how is it that we can't understand some of these matters that are taking place in the district, that we have a fiduciary responsibility to make sure that is running correctly. So I will support this motion.
Ms. Orshak? Oh, no, wait a sec. Earl Campbell, I don't think you've spoken on this. Then go back. Already spoken. Mr. Earl Campbell?
No. Yes.
Yes, go ahead.
Ms. Walton,
Yes, sir.
is there any law or procedures that would stop employee from coming before the board?
Any laws? None that I know of, Mr. Campbell, but I think maybe if the board wants to change the regulations, that might be the direction to go in, because it needs to be clear that the rules that HR follows are the rules that are set forth by the superintendent and the board. Okay. So if the board wants to redirect HR, we will be happy to go in the direction that they point us.
And I understand what I'm hearing is that board members feel, or some of them feel that if the employee does not get satisfaction from the superintendent, then they can bring it to the board. Is that my understanding, Mr. Smith?
No, no, sir, Mr. Campbell. That is. Say it again now. You said that did not
Okay,
give
let's say
satisfaction.
A point of order, Madam Chair.
When they
Go ahead.
I believe this conversation is getting far afield from the actual motion. The motion is to ask the policy committee to draft a policy, not to discuss, as David said, I appreciate his comments, not to discuss the problem right now. It's to send it to committee. And for those on the fence, let me give an example. These
Wait
are
a
two.
minute, you're going beyond your point of order. So,
Okay.
so Mr. O'Campbell, I also understood what Mr. O'Campbell's saying.
Right,
Honestly.
my question is this. Are we asking HR and the superintendent that if a person has a complaint or a concern and they don't get it, be satisfied with the decision that the superintendent make, then are we asking that it should come to the board? That's all I'm asking.
Would you like me to address that? Hello?
Yes.
Was that, yes, actually, actually, if the chain of command should be, first they should agree to their building principals. Secondly, they should agree to HR, and then after the HR should superintendent, and if not resolved at the superintendent level, then yes, then it should be brought to the head, which is the body of a whole, as in the board.
Okay, thank you. That's all my question.
Okay.
So now we're going back to Ms. Orshak.
Thank you. So I just want to understand the motion. So the motion is asking the policy committee to develop a two-part policy. One, identifying or classifying, giving a definition of what confidential is. And I assume most of that will be dictated by law and not the board. And two, the second part of the policy is, and once that's determined, how much of that do we get to be presented with by the board or to the board? I would like to add board and public to that.
May I address that?
Yep.
Okay. Number one, I'm coming at this from the position of an employer, so I'm not sure if the public and the board needs to get the same explanation. But allow me to illustrate in two real-time examples, okay? We get a letter from a constituent with a complaint. We forward it to the superintendent. We call the superintendent a week later. What's going on with this? Oh, it was handled. That's not sufficient. That happens time and time again. The motion is not to participate in the decision of what happens to the employee. The motion is simply to ask the policy committee to develop the policy. Now, as far as your second thing, Ms. Orshak, I think that will run in, I think we'll run into trouble if we have a one-size-fits-all definition of what the board gets for information and what the public gets for information.
So I wasn't speaking the first time around. If it is confidential, if it is deemed confidential by law, then clearly the public wouldn't get it. Okay, so that's the first part of the policy. If the law says this is confidential, you know, per FERPA or what have you, it's not gonna go to the public. But let me give you one example that did go public, okay? That was, you know, roughly considered to be private or confidential. There was a news story that broke a while back about an FBI investigation into a teacher. And this was largely considered to be confidential until we discovered that how it was revealed was by the district itself, that there was an email about it that was posted per a FOIA request on our website, and it had been public information for some time. So, you know, confidential is as confidential does, okay? If it is confidential, then the public can't know it. If it isn't confidential and the board can know it, then the public can know it, okay? It's too often that board members find out about a disposition, you know, on a court website or on social media, and I think we need to, you know, curtail that. That shouldn't be. So I do agree with your motion there. I think the first part of it will be handled relatively easily by the law. It's the second part that'll be open-ended, and I'll be anxious to see what the policy committee brings back on that.
All right, there being no further questions, we're open for voting.
Dowling votes yes.
Voracek, yes.
Yes.
Mr. Williams-Smith?
You have to unmute him.
Thank you, Mrs. Smith. Mrs. Smith, yes.
Voting's closed.
The motion carries 9-1-1, no Guads, and abstention Kathy Robine. So let me just say I just want to say a few things before we recess until tomorrow at 8:45 is when we're going to reconvene. I just want the public to know that there's another public comment section at 8:45 in the morning for 15 minutes. And if you would like to speak, you will need to email your request between 8 and 8:30 to Robin Cushenberry. And that is her email address, and the whole process is printed on the agenda for tomorrow. So we will recess now until 8:45 in the morning. Have a nice evening. Bye.
Bye, everybody.